institutions. There was lack of trust in these institutions, and perhaps where we witnessed incidences like the post-election violence in 2007. And so that era, the pre-2010 era, was defined by a framework that often served the state more than the citizen. Rights were not there, they were elusive, and we felt that Kenya needed a new era. And therefore, leading to advocacy, courage, national dialogue, even bloodshed. We urged and we were able to demand and pursue a new social era, a new constitutional era that reflects our diversity, that protects the dignity of all our people. And that's where we see a very expanded Bill of Rights chapter. And so, as we celebrate today the Constitution of Kenya 2010, we are celebrating not just a document, we are celebrating what was that, our call, that led to, our aspirations, advocacy, courage, as well as national dialogue. We are celebrating what came out of that process. And what we got was the Constitution of Kenya 2010. So we got the Constitution that promised us transformation. It promised us a lot of transformation. We have been able to see devolution of power. We have been able to see devolved government under Article 174. We've been able to see expanded rights, and with a robust Bill of Rights chapter, we've been able to see values and principles of governance, institutions being asked to be more accountable and transparent. In fact, the theme transparency and accountability runs through the Constitution of Kenya 2010. So it is a constitution that has really brought to us social transformation. It is commitment to justice, to equity, to inclusion, and very many other values that are espoused under Article 10 of the Constitution. So as we have celebrated the Constitution of Kenya 2010 as it turns 15, we recognize that its implementation has not been without challenges. We have seen certain judgments coming from the court that move us way forward, that pronounce the Constitution provisions very well, sometimes even enforce rights very well. We've seen the judiciary being independent in certain instances. We have seen socioeconomic rights being, discussed and being, expanded through judicial interpretation. We've even seen devolution of power, and we all can see the 47 counties. But we also feel that there has been challenges. There has been situations where there are gaps with regard to implementation of the Constitution. So this is not new for just our country, Kenya. It's something that happens, but we feel that what was promised has somewhat, there's reason to celebrate, but there are also challenges that we have experienced as a country. So today we are going to be discussing various articles of the Constitution under the Bill of Rights chapter, Article 43, 51, 52, and 53. And as we discuss these articles, we must ask ourselves, how far have we come with regard to realization and securing the rights, the socioeconomic rights, to protection of the dignity of those who are deprived of liberty, to safeguarding the rights and welfare of our children. What are some of the lessons we can draw from the successes and failures, and how do we renew our commitment to constitutionalism in Kenya? And Kabarak University is a university that has shaped a lot of dialogue, even policy dialogue. And I feel that this conversation today will take us closer to realizing or renewing our commitment to constitutionalism, not just in law, but also in practice. And so as I invite us to this session, I hope that this session will be able to reaffirm our commitment and our duty to uphold the Constitution, not just for academia, but even for communities that are represented here. So thank you very much, and I look forward to engaging with us for rich and rich conversations that move us forward as a country. So with that, I would like to just finish that part of my introduction and a little brief of what we are going to discuss today. As I said, we are going to be discussing those articles, seeing how far implementation has gone, and perhaps what are some of the lessons we can pick with regard to implementation of some of the articles, noting that we have experienced key challenges. So I have with me my panelists, as I said, Mr. Young Green, Peter Young Green, Mr. George Skem, Mr. Brandy Kipchumba. We will be talking together with his colleague Faith Mwende and Nara Yego. And to start us off, I will just ask my we'll start off with the panelists who will be able to introduce themselves in person and give just a little introduction of what they'll be discussing. For the benefit of all of us who are in the room, just give a little synopsis of what you'll be discussing, and then we'll come back and delve into the main conversation. For now, let me invite Mr. Young Peter to just give a little introduction of himself and a little introduction of his paper. Yeah.
Okay, na salimu nyote, masal heri. Kwa majina ni Young Green Peter Mudei. Nitakuwa na angalia kipengele cha 43 cha katiba ya nchi yetu. Basically, haki zetu za kijamii na kiuchumi. Asante.
Thank you very much, Young Green. Then we can have the next person.
Assalamu alaikum. Jina langu ni Nara na nitakuwa naongea kuhusu ibara ya 51 ya katiba, that is Article 51 of the Constitution, which provides that which provides that detained people held in custody, people imprisoned, they have a right to retain all their rights. They are entitled to petition for habeas corpus, and the parliament is entitled to enact legislation. That is, hawa watu walio kizuizini wako na haki ya kubaki na haki zao wanapofungwa, na pia wako na haki ya kwenda kotini, na bunge liko na haki, bunge linafaa kuunda sheria.
Thank you. Good afternoon. Yes, I'm George Skem. Na mimi nitakuwa naongelea Article 52. Article 52 is a signpost article or a signpost provision of the Bill of Rights to Part 3 of the Bill of Rights. So generally it's about interpretation, na natumai kwamba tutakuwa na very fruitful discussion tukiendelea. Asante.
Good afternoon, everyone. My name is Faith Njagi, and I'll be handling Article 53 on rights of children, haki za watoto.
Hamjamboni nyote. Kwa majina ni Brandy Kipchumba na nitakuwa naongelea haki za watoto pamoja na mwenzangu Faith Njagi hapa. Asanteni.
Thank you very much and welcome. I hope we are all ready to listen to our panelists who have prepared very well. And so we'll delve right into it. We are going to have at least 1 hour to finish this conversation from when we started. We've already moved on with time, but I'll just start off with Young Green Peter. Would you please expound a little bit, because we talked about the journey of the Constitution and constitutionalism in Kenya. We had pre-2010, which I alluded to in my introductory remarks. Would you tell us how it looked like, how the situation was with regard to economic and social rights pre-2010?
Okay, so thank you so much, Miss Anne. Nitajaribu kuchanganya Kizungu na Kiswahili. So in the pre-2010 era, when I was doing my research, my main focus ilikuwa kuangalia pali ambapo tulikuwa kijamii na kiuchumi kabla ya kuja and having the Constitution of Kenya 2010 na mali ambapo tupo sahi. So it draws back to 1964 when we had our first constitution, that is the Independence Constitution. And fortunately or unfortunately, we did not have socio-economic rights in the 1964 Constitution. Then we know very well between 1964 and 1969, we had 38 constitutional amendments. Out of all those 38 constitutional amendments, no amendment was to the effect of giving effect to the second generation rights, basically haki za kiuchumi na kijamii. Na wakati wa kwanza ambapo Kenya ilifikiria to do something on socio-economic rights, it was in 1976 when we first ratified the International Covenant on Economic, Social and Cultural Rights in 1976. But the problem was one, we were a dualist state. Ilikuwa ili sheria za international laws, for them to apply to our country, we had to domesticate them. So they ratified it, they signed it, but it was not domesticated. So that means it couldn't apply in Kenya. And this went up to 1990 when a report was given by the UNDP, and Kenya was ranked amongst the most unequal states in the world. So basically, inamaanisha Kenya iliwekwa like nafasi iliyo kati ya wale matajiri na wasionayo, walionayo na wasionayo ni kubwa. It was amongst the leading in the world, and that's what led us to first the Bomas draft in 2004. Na hii ndio ilikuwa wakati wa kwanza ambapo haki za kijamii na kiuchumi zilionekana. Lakini unfortunately, when the Bomas draft changed to the Wako draft in 2005, when we went for a referendum, we did not vote for the Wako draft. So you remember hiyo machungwa na ndizi. So hatukupiga kura ya kukubali hiyo. And that's what now changed into the harmonized draft and culminated into Article 43 of the Constitution of Kenya 2010. Thank you.
Thank you for that, Jenny. Brantley. Faith, do you have something to add at this point?
Okay, sorry, Anne, that was Young Green speaking.
Oh, that was Yankee. Sorry, I missed your name. So we'll move right into the next panelist who will tell us pre-2010, Narayego, with regard to realization of Article 51. How was the lay of the land just historically?
Okay, my Young Green has already spoken a lot about how the constitution was back then. So Article 51 did not exist in the 1963 constitution, but we had some laws. However, they were not efficient enough to protect those who were in detention or those who were being held in custody. So wale ambao walikuwa kizuizini mwaka wa 1963 hawakuwa na sheria ambayo ilikuwa inawachunga. Walikuwa, they were exploited, they went through inhumane treatment, their dignity was disrespected, and yeah, so we had a group of activists who fought for the 2010 constitution, and when the 2010 constitution was influenced by the 2005 draft, and so when the 2010 constitution came into action, that's when we got Article 51. Wakati tulipata katiba ya mwaka wa 2010, wale ambao walikuwa kizuizini wakapata haki yao. We are still working on getting to a precise and informative and just implementations, but yeah, that's the history.
Okay. As we continue to pick the history, to see how far Kenya has come, na tuone tumetoka mbali mpaka wapi, na kuona kama tumeweza kurudi nyuma in terms of kuimplement constitution, ama tunaendelea. Ni vizuri tujue historical. So we'll hear with regard to Article 52, George Skem. Just tell us, what is your analysis of Article 52, the rights under Article 52, pre-2010?
All right, thank you. I'll go back to what I said in the beginning. Article 52 is a signpost article. It was a signpost provision to those provisions in the third part of the Bill of Rights. So the third part of the Bill of Rights basically inongelea vulnerable groups. Na vulnerable groups ni makundi ya watu ambao for one reason or another wako na upungufu ama they are not on the same level as other members of the society. So historically, vulnerability is not a new phenomenon. Yeah, historically kumekuwa na many vulnerable groups dating back to the pre-colonial period, and the difference has been the approach towards these vulnerable groups. So you find that in the pre-colonial period, for instance, women were sidelined in leadership. You find that persons with disabilities, sometimes the approach was not that good compared to children. Children walikuwa wanaonekana hao ni baraka kwa familia ama the society. The elderly walikuwa wanaonekana they are wise. So lazima tushughulikie wazee wetu kwa sababu curses may come if those people are not taken care of. But then you find people like persons with disabilities wanaonekana kama ni punishment for our sins sometimes. But then fast forward to the colonial period, you find that there was this phenomena called the center-periphery division, the structure between the people who are conforming to colonial policies and those who are not conforming to colonial policies. You find that those who are not conforming to colonial policies were sidelined from developments. You find that those mission stations zilikuwa set up na missionaries, hapo ndo wanapeana education, hapo ndo wanapeana marketplaces, cattle dips and all that. But then mwenye hata kubali convert to Christianity, you are sidelined, and that creates marginalization, which is a form of vulnerability. Fast forward to the independence period, the government failed to revert ama serikali haikuchukua hatua yoyote kurekebisha the situation that was in before the independence. So you find that Article 52 or a similar provision to Article 52 on vulnerable groups and the third part of the Bill of Rights did not feature in the Independence Constitution or the repealed Constitution. And that's now culminated to what we have now, because maazimio ya watu during the constitutional making period before the 2010 Constitution was promulgated ilikuwa kwamba we need social justice. For us to have social justice, lazima watu wenye wanaishi na ulemavu wakuwe catered for. Na watu wanaishi na ulemavu, they cannot have the same level of protection when it comes to law as those people who are abled. The same thing to elderly, children, youth, marginalized communities. So we wanted social justice essentially, and that's why we have Article 52. That's the historical perspective behind it. Thank you.
Thank you. We can hear the history of Article 53.
Okay, so Article 53, as I had already stated earlier, deals with rights of children. And so when we think about children, we know that everybody here knows that children form a very integral part of the society. And when you look at the history, dating back from colonization, children were invisible in the law. And when you look even at the 1963 Constitution, even after we gained independence, children still, the rights of children were still not involved in the Constitution or written down. But over the years, we have seen initiatives or a revolution, and tunaweza sema it began as a result of maybe some presidency, and during, let's say, I think we are all familiar with the utawala ya Moi when he introduced the Maziwa ya Nyayo program. So this is an initiative which he began at that time, despite there being not a specific provision that was providing for rights of children. We're seeing this initiative coming up, and it was meant to at least promote the welfare of children in schools. And this is not the only one. We're also seeing during Kibaki's tenure, when he comes up with his agenda to remove illiteracy, and so he brings in the free primary education program. And hizi zote, all these are initiatives zenye zimekuwa over the years, because there hasn't been a set standard or provision that has been providing for up until now the Constitution. And I can say this is the history that has shaped the contents or what now we see in Article 53, where now children are able to enjoy name and nationality from birth. They're able to go to school and access like free primary education. So it's a result of that history that has shaped the how we are today and how the Constitution is with regards to rights of children. So that is a brief history that is dating back or summarizing or showing how we are seeing the Article 53 and the contents of what it entails. Yeah.
Thank you very much, Faith Njagi. Mr. Kipchumba, would you like to add anything, or well covered by Faith?
I think that part is well covered by Faith. I will proceed in the next section.
Thank you, Kipchumba. But I think in summary, what we are seeing from our panelists is there has been limited human rights prior to 2010 Constitution. Rights such as economic and social rights was nowhere. Kenya was recognized as one of the most unequal states by UNDP, and we've also seen that rights such as the rights of persons held in detention, vulnerable groups, and even the rights of children were very limited. But what we have now is not just these rights being guaranteed in paper, but at least they've been pronounced through the Constitution. And we'll be wanting to hear and learn what the Constitution has come to cure in terms of that limitation of rights. As I said earlier, we now have an expanded and a robust Bill of Rights chapter. In fact, the Constitution of Kenya 2010 is one that is hailed across Africa as a document that very many other jurisdictions can borrow from. And as colleagues have very clearly espoused, we came from, tumetoka mahali, rights za binadamu hazikuwa recognized. It was at the will of the people or the president or of whoever was in power. Ni ile tunasema we came from very far with regards to realization of rights or even recognition or even pronouncement of these rights. And so now we have the Constitution of Kenya 2010, which is 15 years today. And I'll start by asking my friend Youngling Green, Peter, what would you say and what can you present to us with regard to Article 43 of the Constitution? As Kenyans, what do we have under the Constitution with regard to what you told us was not recognized previously? Where are we?
Okay, thank you so much, Anne. So right now, we have our Article 43 of the Constitution of Kenya 2010, na inasema haki tano ambazo uko nazo kama mwananchi. So uko na haki ya afya, uko na haki ya kukaa katika makao mazuri, uko na haki ya kupata chakula, haki ya kupata maji, haki ya kupata elimu, na haki ya kupata what we call social security. So mambo ya afya yako and all that kushughulikiwa, ili wakati ambapo unapata shida, unaenda katika hospitali na upokee matibabu bila kulipa ile kiasi ya pesa ambayo ungelipa kama una hiyo. So when I was looking at this, the first thing that I tried to look at, nilikuwa najaribu kuangalia wakati mahali ambapo tulikuwa katika kipindi cha 2010 na 2013 na mahali ambapo tupo kipindi cha 2022 na 2025. So ukisoma data that's available in the internet, as of between 2010 to 2013, 4 out of 10 Kenyans were living below the poverty level. So basically to mean, watu 4 kati ya watu 10 katika nchi yetu walikuwa wanaishi chini ya $1.25 US, which translates to about 150 or 200 Kenyan shillings. So shilingi 200, watu 4 kati ya watu 10. Ukiangalia the data as of 2022 to 2025, the percentage still stands at 39.8. And if you do the conversion, it translates to bado 4 people out of 10 people in Kenya as we speak live below the poverty level. So they depend on chini ya shilingi 200 kwa siku. So, because I love speaking of reality, let me get out of the law. And the question that now you have to ask yourself is, sisi kama wa Kenya, shida iko wapi? Mbona uchumi yetu na afya yetu na hizi vitu vingine they don't become better with time?
Recording in progress.
And the first answer that I get, the first killer of Article 43, because Article 43 depends on 3 things. So anytime you wanataka kufanya sheria ije na iguze wananchi, kuna vitu vitatu ambazo lazima uangalie. So the first one is the political will. Je, wanasiasa wetu wako na ile, do they have the motivation to ensure that they aid us in implementing the law? Then the second thing, do we have the resources for implementing Article 43? Then the third thing, what role does the judiciary play in implementing the Article 43 provision? So if we are able to answer these 3 things, then we are able to realize Article 43. Makosa ya kwanza ambayo tumefanya kama wananchi ni the first tenet, political will. Tunachagua viongozi ambao wanaangalia tumbo yao na hawaangalii maslahi yetu kama wananchi. Wacha niwape mfano. Article 43(2) of the Constitution of Kenya states clearly that wewe kama mwananchi uko na haki ya kupokea matibabu ya kiafya ya dharura, so emergency care. So at any time you have a sick person at home, mtu ambaye ameugua vibaya na umpeleke hospitalini, inafaa huyo mgonjwa ahudumiwe kwanza, akishahudumiwa ndio uombwe pesa. Hiyo ni kitu ya dharura na afya yako. Lakini mpaka leo mwananchi ataenda hospitalini, kitu cha kwanza, hospitali ya kiserikali, kitu cha kwanza utaambiwa leta pesa ya dawa, leta pesa ya hii. Alafu kitu cha pili tena, ukisoma Article 43(3), it says that the state has a duty of covering your health care. But tumeona kitu ambacho kinafanyika, kila mtu anaambiwa, oh, you have to pay 300 for your social health care and all that. So those are some of the good things that are there in Article 43 that if we take time well, we'll be able to implement them and achieve whatever is there. So I pass it, then I'll give the recommendations later. Thank you.
Peter, before you go to the recommendations, maybe just something to pack later. Do you see like the courts are making any progress towards realization of Article 44 problems? The economies, politicians, with regard to political will. Maybe you can tell us, do you see there is progress that is coming out, especially through judicial pronouncements? Unaona kama koti za Kenya zinasaidia Wakenya kuweza kupata haki zao za Article 43. Maybe you can pack that and tell us as we go to the recommendations. But okay. After, and I know I lost connection at some point. I wasn't able to follow, but maybe we can give a few case summaries later on how courts have been able to bring out this later on. For now, we will go right into Article 51 with Nara to see how the lay of the land looks like. What does the Constitution say? Na tumeweza kupata hizi haki kama wa Kenya. Nara, please.
Okay, Article 51. First of all, we would acknowledge that, as I said before, Article 51 did not exist, but it exists now, and it has 3 parts. The first part is all the detainees, all the people held in custody, they have a right to retain all their rights unless they are limited by law. So when someone is arrested, when someone has been held in custody, when they go to the police station, they have a right to shelter, they have a right to a clean environment, they need to retain all their rights unless the right to liberty because they're in prison. So the second one is the detainees are entitled to petition for habeas corpus. As much as you're going to prison, or as much as the police officers have deprived you of your liberty, the person who has been detained is entitled to petition for habeas corpus. Okay, according to this article, when I was reading, I found out that, okay, it is a fact that you are not supposed to stay in detention for more than 24 hours. So after 24 hours, you're supposed to either be released or file a petition, go to court. Yeah. So the third one is Parliament needs to enact legislation. With regards to international law obligations, it is very clear that when a person has been detained, they need to retain their dignity. So this person has a right to humane treatment. They have a right to be treated as a human, even though they have been deprived of their liberty. So we have bodies like the Independent Policing Oversight Authority, who conduct reports and inspections and have come up with mechanisms where they go to the prisons, they check if the sanitation is good, wanaangalia kama ni kusafi, if the person is staying in a clean environment. Yeah. We also have the Kenya National Commission on Human Rights, where they inspect and they just ensure that this person who has been deprived of their liberty is still enjoying the rights of a normal citizen.
Thank you. Judge Skem, once again. Now, with Article 52 is essentially, Article 52 is a signpost article, once again. And it talks about interpretation of the provisions in the third part of the Bill of Rights. What this means is that even as courts apply the provisions of the Bill of Rights, the rights in the third part of the Bill of Rights are not exhaustive to those vulnerable groups in the Bill of in that part of the Bill of Rights. So for instance, you as an elderly person, Article 57 inasema kwamba as an elderly person uko na haki ya participate in the activities of the society. That provision is just amplifying the rest of the Bill of Rights. Activities are the community or the society, they include voting, and those are political rights. They include owning property, and those are property rights. So the Constitution, or the drafters of the Constitution, waliazimia kwamba, even as we interpret the Bill of Rights and interpret those provisions in the third part of the Bill of Rights, we do not limit them. So those provisions are not supposed to be limiting. They are supposed to be reinforcing the provisions in other parts of the Bill of Rights. And this has been shown, like the jurisprudential history of the Kenyan courts since 2010 has shown that courts have embraced this way of holistic interpretation of the Constitution, where haki zenye ziko kwa Article 53 for children are being linked to other rights. For instance, you see there's a case here, Satros Ayuma versus Trusted Committee on Railways. So you find that the court is saying the children have been affected by evictions. Evictions will deprive them the right to housing. They have a right to shelter in Article 53 as a specific right, lakini bado wako na the right to housing in Article 43. So that's the essence of Article 52. Article 52 imekuja kuprotect in that those people who have been designated as vulnerable groups, hawatakuwa wanaambiwa ati nyinyi mko na your rights in Article 53, mko na your rights for PWDs in Article 54, but then the courts have embraced that and have ensured that in interpreting or in reading or in referring to the rights in Article 53 for children, those rights also relate to Article 43 on housing. So we have the general right in Article 43, but pia tuko na the specific right for children in Article 53. You have the general right in Article 43 on housing, you have the general right in Article 38, those political rights, but then you have the specific right in Article 57 for the elderly, and that's the essence of the interpretation that the drafters of the Constitution intended that will be adopted after the 2010 Constitution was promulgated. Thank you.
Thank you very much. We'll now just hear the text of the Constitution with regard to Article 53. Brandley and Faith will share that session. I will just give each person 3 minutes to give us a little bit on Article 53.
Okay, thank you so much. Article 53 deals with the rights of children. So the article has two parts. That is the first part mentioning the rights of the children, and the second part which mentions that the best interests of a child are paramount in any decision concerning children. So, on the rights of children that we have in the Constitution, they have the right to name and nationality, right to free and compulsory basic education, protection from abuse, torture, neglect. They also have a right not to be detained, and if they are detained, it should be a measure of last resort and for the shortest period in conditions that consider the age and the gender of the child. There is also parental responsibility, equal parental responsibility, whether the parents are together or not. So as much as children rights, I will speak about, from 2010 till now, I will speak about 2 or 3 rights. That is, the first right I will talk about is education. The children have a right to free and compulsory basic education. So tulipoanza 2010, most of the children walikuwa wanakujiwa kama waendi shule, unapata mzee wa kijiji ama chief wamekuja kupeleka watoto shule. Lakini kwa sasa ukiangalia the debate that is going around education, you find that most of the leaders, political leaders now, they're reducing the budget going to education. And okay, I believe most of us have also seen the news. From the news, you've seen that there are some schools in various parts of the country that are in deplorable conditions. So that raises concerns about the quality of the education that the people are getting, the children are getting. So it is free, yes, but why are you giving free education in a structure that is not habitable or favorable to education? There is also, okay, education goes hand in hand with malnutrition and the nutrition of the children. As parents, I know back at home, you take care of your child, you give them food and everything. Then in some areas like the arid and semi-arid areas, you find that most of the children maybe take a meal or, a meal in a day. So the government had rolled out a program, that is the school meals program, which is to give the children meals, at least a lunch while they're in school, so that increases enrollment. But you find that from when it was started, I think it was started in 1980, by 2008, it was only 1.6 or 1.8 million children under the program. So from 2008 to 2022, the population, the number of children had increased to 1.5, and now 2025 we have 2.6 million learners under the program, and the government targets 10 million learners by 2030. That is 5 years to come. So considering they've taken that period from 2022, 3 years now, they've taken long to increase 1 million. That you can also see that the resources being allocated and stuff are very limited. So achieving that goal in 2030 would be very low. I'll also talk about protection from abuse and neglect. Many children now are exposed to online, like they have access to smartphone. Looking at the current society, many children, they can be abused online. That is like the child sexual abuse material being passed to them. They are groomed and abused in various ways. So there is also need, as parents, you can also look into that. Maybe because, okay, as a child, I know a child who is abused cannot tell you, but if the communication with the child is improved, maybe they can tell you and you can help with that. There was also the case of Maimayu, where children run away from home, then they find themselves in the hands of perpetrators. I think the enforcement of this article is still very low. Yeah, thank you.
Thank you very much, Kipchumba. Perhaps, Faith, if there's something to add before we move on to a plenary discussion?
No, I do not have anything to add.
Thank you, Faith. And thank you so much, panelists, for bringing out what has been there before 2010. You've really taken us through how the situation looked like pre-2010, and clearly rights were very limited. Now, we saw 2010, we've had an expanded conversation around Article 53, 51, 52, and 53. But the question remains, do we only have these rights kwa karatasi, kwa constitution, ama tunaweza kuzirealize kama Kenyans? Na ni kazi gani tunaweza fanya kama jamii, wale wako hapa kwa this forum? What can we do as a community to ensure that we are watching what is happening? Constitution ndio hiyo tumeelezewa, na imepeana very good rights, lakini sijui kama kila mtu anaweza realize the rights that are already on the constitution, under the constitution, and what can we do together kama jamii, tutafanya nini ndio tuweze kurealize the safeguards provided by the constitution. In addition to that, mnaweza ona kwamba in the country, especially recently, Kenya National Commission on Human Rights, kuna mtu ametaja Kenya National Commission on Human Rights, wamedocument very many cases of enforced disappearances. How does that sit with the rights of Article 51? Pia tunaona kwamba as a country, their efforts to give universal health care, there are challenges there. Tunaona pia watu wanatolewa kwa boma zao, cases of evictions. Maybe let us think about these rights that are under the constitution and what is happening realistically on the ground. How does it look like? And with that, I just want to invite my colleague Nelly to take us through a plenary session for people to engage with the panelists, and maybe ask the question to the specific panelist, or if it's a general question, we will decide who can respond to it. So in the interest of time, we'll go right into plenary. Nelly, please take it on.
Okay, so due to time, we'll have 3 questions and 1 question per person. So we can start.
Oh, thank you for the wonderful presentation. Mine is a PowerPoint question. I have 2 slides. Slide number 1 ni katika kipengee cha 43, moja the high mambo ya afya, moja tunaambiwa about the highest standards of health, attainable standards of health, but many a times you go to a facility unakuta kuna zile levels of ukijua the health ecosystem iko na level 1, level 2, level 3 up to level 6. Mara nyingi unakuta kwamba kuna huduma unatakiwa upate katika level fulani azipo. That is also a violation of right. Maybe umeenda level 5 unakosa vitu zingine. That is a violation that we need to be aware of, and we need to be maybe looking at it. And in the interest of time, sitasema mengi. Health should be based on 3 A's and 1 Q. Availability, accessibility, affordability, and quality. Kama utakumbuka chochote, kumbuka 3 A's and 1 Q. Thank you.
Thank you.
Jambo. Kwa majina yangu ni Florence, nimetoka Barina. Kuna kitu ambayo ningeuliza juu ya watoto. Katika community, sijui ni nini imekula watoto wetu wa siku hizi. Kwa sababu wanaenda wanapata watoto, wanaletea sisi wazazi tulee. Na samani, tunarudi sasa samani. Hata kama mimi sio mzee sana, lakini sijawahi kuachia mama yangu mtoto. Lakini wakati huu katika community kwa vijiji, hata nikiingia hapo Barina, kila nyumba unakuta msichana alizaa kaenda. Je, ni upende ilikosa ya watoto wao ile ya kimungu au ni nini? Kwa sababu sisi, nimesema mimi sio mzee sana, lakini mimi ni mzee. Wewe msichana ukiolewa au kijana ukioa, unajua kwamba utakuwa na familia huyo kuanzia mtoto. Mnamlinda nyinyi wenyewe. Mimi ninaitwa shushu, ninaletwa kama zawadi. Lakini leo sio zawadi, leo ni mimi ninalea. Leo ni mimi ninalea. Sasa paka imefika leo tumekumbuka, mimi leo hata wangu Mimi nikiona akilia sana akunywi hii maneno mnafanya, mimi nashika hivi. Napatia ile kisamani, mtoto anakunywa uji. Na mama mwenyewe ameenda. Je, ni nini imekula watoto wa siku hizi?
Asante sana.
Yangu ni kwa majina ni Patrick Barasa, under Article 43, access to clean and safe water. Nakuru County, it's a fluoritic zone. Tuko na fluoride kwa maji ambayo inaharibu mafupa na meno ya watu. Through that article, how can we actualize for the community to access clean and safe water, either public funded or private? Thank you.
The last question.
Yes, mine is that to enjoy those the rights that we have been given by those articles, then we should tie them to, I think is it Article 4 or that what on access to justice? If you do not tie them to that article, we'll never realize those rights. Number two, for them to be realized, we need pressure from the community. And that is where the role of civil societies, informed citizenry, can at least demand for their rights. And I'll give an example whereby we have a case, a very famous case in Nakuru, whereby the two parents, they do not, okay, they are deaf, two deaf parents. They get a kid at PGH and then the kid disappears. Unajua wajui kuongea, the rights of the vulnerable or the marginalized. So akienda kuita daktari kuja tibu mtoto, anapata mtoto amekufa na ameenda. The following day they come with a coffin to collect the body. Wanaambiwa ya kwamba mtoto alipotea, mnalilia nini kilo 3 na zimeshafanya nini? You can imagine that, the rights of the vulnerable and the marginalized. So my concern is civil societies do play a very critical role in that. We went to the ODPP's house. It was supposed to be, they had an inquest file, meaning kwamba wanafanya uchunguzi mtoto. They were still under investigation, but you had to push until ikafanywa criminal court. So to access those rights that you have mentioned there, we need to tie them to the article on access to justice and then pressure from informed citizenry as well as civil societies. Thank you.
Thank you. Thank you very much. Are we able to take one more? Oh, that's it? Okay. So for question 1, I'll request Youngling Peter to handle it. Question 2, we can on the morals and the rights of the child, we can have Kipchumba handle that. And on question 4, on the rights of clean and safe water, Article 43, we can have Peter again respond to that. And then on realization of rights, maybe Faith can respond to that. How do we move to realization of these rights?
Okay, so thank you so much. I'll handle the questions conclusively. So the first one is on the issue of highest attainable standards of health. So kuna shida kidogo katika katiba yetu. Juu katiba yetu inasema we are supposed to do something called progressive realization of social economic rights. And there is an exemption wakati ambapo serikali inaweza kuja na iseme hatujafanya 1, 2, 3 kwa sababu ya hii na hii. And that has been the story that we've been hearing. Anytime mtu anaenda kotini na anasema serikali haijapeleka maji hapa, serikali haijaleta afya hospitali hapa, watasema we don't have the resources for doing the same. But the good thing is our courts are doing a very good job. And this applies now to our women. There is this case, a very famous case in Bungoma, County Government of Bungoma versus Josephine Oindo, before the Court of Appeal, Justice Ngugi. So story in brief, kuna mama ambaye alikuwa mimba na akaenda hospitalini. Wakati wa kwenda katika hospitali kujifungua, alinyimwa kitanda, akanyimwa the basic things that they require for her to deliver the baby safely. Na aliishia kuzaa on the floor in a corridor in the hospital. So when she went to court, whatever Ngugi said is progressive realization doesn't mean that we don't have some things that we can achieve immediately. So alisema kitu kama wewe kama mama daktari kukuongelesha vibaya. Daktari akikuongelesha vibaya, unaweza enda kotini, utapewa haki yako. Daktari akikupiga kofi, wasipokupea kitanda, vitu kama if they discriminate you, you can go to court na utapata haki yako. So wamama katika hii chumba, kitu kama hiyo ikifanyika, tafuta wakili, tafuta mzee wa kijiji, fika kotini. Josephine Oindo was given almost $1 million, more than $1 million. Then on access to clean water and safe water, I've had that problem with Nakuru. Shida ya kwanza na Nakuru ni being overcharged, even before you go to fluoride and all that. Most houses in Nakuru sell water at 500 shillings per unit, but the law stipulates it's supposed to be less than 100. That's a problem we are facing on this side. Then definitely the county has a problem, and I know that talk has been going on with the governor for Nakuru County. They should definitely come up with a power plant that can treat the water, because that is the role that they're supposed to do. And wasipofanya hivyo, it's simple. We have our elections, na kama ni MPs wetu, right now we have something called right to recall. Tunaweza chukua signatures zetu na tuseme, kwa sababu wewe kiongozi na wewe kiongozi hautusaidii kupata haki ya maji na haki zingine in Article 43, tunakupeleka nyumbani, and we elect someone who can help us. Thank you.
Kwa swali la mama, nini imeingia watoto wetu wa sasa? Ningependa kusema kwamba kama wazazi ni jukumu letu kuweza kuongea, kupa mawaidha watoto wetu. Okay. Hata kama mimi nimefika miaka 18, nimepita miaka 18, lakini nikiongea na mzazi namsikiza. So kwa hivyo usione kuwa amekuwa mkubwa, anaweza jiamulia mwenyewe. Wewe umuite, zungumza naye, natumai atasikiza. Kwa kuwa sasa unaona kama watoto alafu wakuletee, ni kama sasa haki ya huyo mtoto ambaye amezaliwa imekuwa violated, kwa sababu watoto wana haki ya kulelewa na baba na mama vizuri. Sasa ni kuzungumza tu na mwanako, mwambie hii na hii, atasikiza natumai. Asante.
Na pia, as I answer my question with regards to realization of rights, I can also add to the fact that implementation is also something that is key with regards even to the question yenye mama wetu ametuuliza siku ya leo. And also it's a problem that we can all see, because now when we look at the Constitution and even acts of Parliament, they have tried to create duties. They have actually given parents and the state and even the society duties and obligations to ensure that children get to access these rights, and we can term them as the duty bearers, but at the end of the day, they have not, there is no a distinct way that has actually provided that this is what you're supposed to be doing with regards to implementation of children's rights. And so that is an example of now the parental care, children having a right to parental care and protection. So since that right is not effectively implemented with regards to who has the response, how are we going to ensure that parents actually at the end of the day come and make sure that their children are accessing every single right, or they're actually getting the care that they deserve? So that is with regards to realization even in general. Na tunapata ya kwamba when now even us as a community, everyone who is seated here, we actually have a role to play in the lives of our children. But when it comes to accountability, now that is where we find now question marks. Because let's say if something were to happen, or even the instance that was used for the Mahimayu case that Brani had mentioned earlier. So from that case, there are obviously people who live in that society and members of community, but that drive or that responsibility or knowing the duties that they have or the roles that they have to play in their children. Kama kitambo, we have had stories of how mtoto hata ange, in the past, like kitambo, how children, they could be wanaweza, like any member of the community akipata mtoto wa neighbor hata akifanya anything wrong, they have like that power to, you know, discipline them. So we have to take steps as individuals, even as we are seated here, to ensure that even children are actually getting to, you know, to enjoy their rights. And I think that is a step forward with regards to realization of rights for children. So thank you.
Thank you very much. I'll just ask one question to one of the panelists, George Skem, if you can just give us brief remark on what can we do as a community. Sisi wote tuko hapa, tuko na kazi ya kuhakikisha kwamba constitution inafuatwa vile inafaa. What can we do as different parts of the community? Tukitoka hapa, tutasaidia aje kupata hizi rights zenye ziko kwa constitution. It's very clear that there has been a problem with the implementation of all the rights. But what is our duty? George.
Okay, thank you. Indeed, there is a problem with implementation. Rights exist. The courts come and interpret the rights. The courts come and interpret the laws behind those rights and everything. Lakini hapo kwa implementation ndo kuna shida. But then there's a way out. Even as a community, where we see our leaders are not coming in to implement the provisions and the rights and all those duties they have, we also have a duty. Hii katiba si ya viongozi, hii katiba ni yetu. So, you as an individual, what are you doing to advance the implementation agenda? Activism and advocacy. So, you look at practitioners and judicial people, judges, we need judicial activism, yes. But us, kama the watu wenye tunaumia sasa, if this implementation is not achieved, what are we doing? We need advocacy. Wenye tumekaa hapa, we need advocacy and we need that activism ya kupush. I'm happy that Mr. Baraza may point out that sometimes they even have to go and some sort of like threaten the MP. Wamwambie, if you don't do this, we'll move to the High Court because it's our right. So we need to also ensure that tuko hapo, we are not just waiting on the people or the leaders to deliver, because you may not know, utakaa 5 years, una-elect mwingine, unakaa 5 years, una-elect mwingine, and nothing is being done. But you as an individual and as a community, you can all come together for advocacy. And of course, we need to sensitize our people and ensure that even those of us who are in this legal field, tukifika huko mbele, we exercise judicial activism. Those of us who are going to become leaders, yes, we can do better. We can always do better. And the Constitution will deliver. Yeah, thank you.
Thank you very much. I'd like to end it there. We have come to the end of this session, and we have learned that we have come a long way as a country towards safeguarding rights. And it is our joint responsibility to ensure that our rights are being implemented the way they should. And as we celebrate 15 years of the Constitution, I'm sure we'll celebrate even 50. As we celebrate 15 years of the Constitution, we all have a duty to safeguard the Constitution, to seek accountability from the government, and to monitor that the Constitution is being implemented right. So please join me in thanking all of you for coming. I think the first thing that has been said is we must engage as a community, and coming here is one of those things that are first thing. And secondly, to thank our panelists and call to an end this session. Thank you very much.
Thank you very much, Anne. It's been a pleasure having you for this session. You've done an excellent job. We want to move straight to the next panel. So I will ask the next panelist to come on stage. So we have Hiltruda Nyokabi, Joan Kiptui, Ian Ekisa, Gloria, and Jacinta Kanda. Okay, So before us, we have the next 4 panelists. Ian and Gloria will be handling persons with disabilities. Hiltruda will be handling minorities and marginalized groups. The youth. Jacinta Kanda will be handling minorities and marginalized groups, while Joanne, is Joanne here? Yes. Oh, Joanne is online. Joanne, are you with us? Please ensure you promote Joanne to panelists as soon as possible. We'll be doing older members of the society, as we've had already. Our mom ameshatuambia kwamba si mzee lakini ni mzee. So maslahi yake yanakuja kushughulikiwa sasa hivi. This panel shall be led by Miss Luciana Thuo. I am privileged to have known Miss Luciana Thuo for the last 20 years. She is, and in those 20 years, she has been an excellent legal mind from when she was very young until now. Luciana Thuo is an expert in elections law and governance with over 13 years experience. She has an LLM from the University of Pretoria, diploma in realizing human rights through criminal law from the Abo Academy in Finland. She has a Bachelor of Laws from the University of Nairobi, and she was admitted to the bar after a postgraduate diploma in law in 2012. She has an impressive career trajectory that includes roles such as research coordinator for the Kenya Judiciary Committee on Elections, research on political disputes and tribunal. She is currently a legal analyst, a lead legal analyst in Sierra Leone's cross-party committee on electoral systems and management bodies review. She has also served for a long time here as lecturer, head of department, and associate dean. And she was one of the founding editors of some of our journals. Many of our forums were begun by her or facilitated by her through the years. In addition to her professional roles, she has consulted with prominent organizations like IFES, NDI, UNDP, ICJ Kenya, LGA, FIDA Kenya, and the KATIBA Institute. And she is a prolific writer. She has the most writings in Kenya on elections law, including summarizing all elections, laws, and cases from 2012. All books on that area have been written by her. So she's a very impressive person. I am privileged to call her not only my friend, but also a great source of inspiration. Welcome, Luciana.
Thank you, Sam. Good afternoon, everybody. Kindly confirm whether you can hear me clearly.
We can hear you quite clearly.
Okay, thank you. From what I understand, we only have an hour for this session, maybe slightly less. So allow me to just go straight to the session so that we allow sufficient time for question and answer. This is what I am proposing to do for our session because I understand it's been a heavy day already. I am proposing that we just have the panelists speak for about 6-7 minutes each and tell you what they have put in their commentary. And then I'll give some initial feedback on what my assessment was when I read the commentaries, and then we can open up the floor for audience engagement because that's primarily where we're going to get the feedback from. So because the session is on operationalizing Articles 54 to 57, we will go in the order in which the material was written. So from Article 54 on the rights of persons with disabilities, and then we will end with Article 57, which is on the rights of older persons. So Ian Ekisa, I believe, will lead the discussion on that, but he can tell us. So I want him to just give an overview of what they put in the commentary, what they thought the improvements on the rights of persons with disabilities are under the Constitution and what is the way forward. And then we can hear from Nyokabi, and then Jacinta and Joanne in that order. So Ian, allow me to just yield the floor to you. I don't want to eat into the discussion time. I will come back with my own comments after we have done the initial presentation.
Jambo. Asante sana. Mimi naitwa Ian Ekisa. Mimi pamoja na Gloria Njeri hapa kando yangu tumefanya utafiti kuhusu haki za watu wenye ulemavu ambayo iko katika kipengele cha 54, na katika utafiti huu tulianzia tu kuangalia historia vile ambavyo mambo ya watu walemavu imekuwa, na tukagundua kwamba pale kabla ya uhuru wa Kenya ama pre-independence period, jamii ilikuwa na wazo mbaya ama wazo potovu kuhusu watu walemavu. Sana sana waliweza kuona watu walemavu kama watu ambao wamelaaniwa ama watu ambao wamepozwa na mapepo, yani evil spirits, ama pia watu ambao wana bahati mbaya katika jamii. Sasa hii ilifanya kwamba jamii ikatenga watu wenye ulemavu kama vipofu na kadhalika. Kusongea mbele baada ya uhuru, katika kukakuwa na katiba ya nchi ya Kenya ya mwaka wa 1963 ambayo ilikuwa na vipengee ya kuzuia kuwatenga watu mbalimbali ama clause of non-discrimination clause by the state or by any person. Lakini sasa hii katiba katika all the grounds did not mention disability as a ground of non-discrimination under section 82 of the repealed constitution. Hata hivyo kusongea mbele zaidi kufikia mwaka wa 1959 watu wenye ulemavu wakakuja pamoja na wakaunda association yao ambayo inaitwa United Disabled Person of Kenya, na wakaanza ku push forward the agenda au kutetea haki zao. Kisha kufikia mwaka wa 1981 Kenya pia bado katika lengo za kitaifa, nchi ya Kenya kwa mfano mwaka wa 1981 ikasema mwaka huu ni mwaka wa watu wenye ulemavu Kenya yote, na kufuatia mwaka wa 1981 katika mataifa ama at international level, United Nations pia ikasema mwaka wa 1981 itakuwa ni mwaka wa 1981 itakuwa pia ni mwaka wa watu walemavu katika dunia nzima. Lakini kingine kikafanyika mwaka wa 2003 ambapo sasa tulipata sheria ya kwanza ya Persons with Disability Act of 2003 ambayo sasa iliweza kueleza haki za watu wenye ulemavu, ikawapatia haki ya afya, haki ya kuajiriwa na kupata ajira, haki ya kupiga hata kura na kadhalika. Na zaidi tunapata sasa kuona the 2010 constitution ambayo in article 54 inapeana haki zaidi ya watu walemavu katika taifa letu, haki ya right to access all places, for example all places, right to be treated with human dignity among other rights ambayo iko katika article 54. Na pia most important thing again to mark is the 2025 Act of Persons with Disability, which has been enacted this year. Yani baada ya miaka kama 20 ijayo, kwa sababu 2003 ndio kulikuwa na the first act of persons with disability, lakini watu walemavu wameweza kupigania zaidi haki zao, na mwaka huu president wetu akaweza kutia sahihi sheria ya Persons with Disability Act of 2025 ambayo nikipata muda pia tutaweza kuchanganua, kwa sababu imekuja na mambo mageni sana ambayo tunatumainia itafanya kazi na kuweza kuwasaidia persons with disability. I think those are the laws, those are the legal frameworks behind Article 54. As well, in the international legal frameworks, we also have the United Nations Conventions on the Rights of Persons with Disability, which is important to note that was ratified in Kenya even before the promulgation of this constitution that we are celebrating 15 years, which was that was in 2008. So the question is, the good thing is in 2025, the 2025 Act aligns now with the United Nations Conventions on the Rights of Persons with Disability, because the 2003 Act, as I said earlier, had been enacted just before the ratification of the United Nations Conventions on the Rights of Persons with Disability and the 2010 Constitution. Yeah, thank you.
Thank you, Akisa. And it's true, your commentary does a very good job of tracking the history of disability and why, from both a religious standpoint and a legal standpoint, people with disabilities were not considered equal in dignity with other human beings. So I think your commentary makes a fantastic point that even biblically, people who were disabled were not allowed to make sacrifices, make offerings to God. Culturally, a lot of people who had children with disabilities would hide them. And that also translated into the way the law saw people with disabilities. And if you look at the Persons with Disabilities Act, which is what you focused on in your commentary, you'll see that the format of the act is what we call in the human rights framework a welfare model. It's this idea of tusaidie tu walemavu, let's just help them along. They're not equal to the rest of humanity, but let's just manage them until they leave. Which is a framework which is not only lowering of the dignity of persons with disabilities, but is very limiting in their progression. I like to ask this question. Most of us have grown up in societies where you've seen a person with a disability. So if as a child, you may have seen someone who was visually impaired or they had a hearing impairment. As you grow up in the ranks, as you go to school, as you go to universities, do you see those people? I keep asking this question. In law school today, how many people with disabilities do you know? According to the census, there's at least 5% of people with disabilities in Kenya. So, hao watu wako wapi? And part of the problem is that the way in which the law is structured, the way in which society has been structured, is to manage people with disabilities, what we call the welfare model, as opposed to dignifying them as equal members of society, which is a human rights model. So what you're talking about with the CRPD is this idea of we must dignify people with disabilities as human beings who are equal in dignity to other able-bodied persons, which is a very important development. And as you rightly pointed out, our act for a long time was behind the CRPD, yet, which is ironical, Kenya was a huge part of the drafting of the CRPD. Kenya was a lead contributor to the CRPD when it was adopted at the UN level. And so it was only befitting that was 2006, and it was only befitting then that we would come back at the local level and make provision for people with disabilities. I'll come back later to how I think the commentary can be strengthened. But allow me now to introduce the next person who will give us their discussion on Article 55, Article 55 being on the youth, and this is Hiltruda Nyokabi. Hiltruda, the floor is yours.
Thank you, Madam Luciana. Hamjambo adhuhuri hii. Kabla tuendelee, amsha neighbor. Naona watu wamelala huko. Amsha neighbor. Sasa tutaanza kwa kuzungumzia Article 55 ya katiba yetu ya 2010. So what does Article 55 entail? So Article 55 discusses the state obligation to take affirmative action towards realizing the rights of the youth, including relevant education and training, opportunities to associate, be represented and participate in political, social, economic, and other spheres of life, to access employment, and finally, to be protected from harmful cultural practices and exploitation. So to talk about the historical background of this provision. Was this provision existent before 2010? The answer would be no. So before 2010, or rather under the Independence Constitution of 1963, this provision, or rather the youth rights, were not explicitly recognized as a distinct category of rights that needed to be of concern. And this also applies to the subsequent iterations. By subsequent iterations, I mean the Constitution of Kenya Amendment Act of 1969 and the rest. They still did not recognize youth rights as a constitutional concern. So what I mean by this is that pre-2010, the rights were individualistic, adult-centric, and they were universal rights that did not give regard to the vulnerabilities, or rather the developmental needs of particular social groups, and in this case, the youth. So what led to the inclusion of Article 55? What was the rationale behind the inclusion of Article 55 in the Constitution? So under this, we're going to discuss a story of, or rather a crisis of neglect, and we're going to look at the historical and socio-economic context. So prior 2010, as I stated, Kenya's framework offered no recognition of the unique status and the needs of the young people. So this silence entrenched the structural invisibility of youth within different aspects of life, as, for instance, national governance, law, and policy. So what was the result of this? The result of this was that young people were confronted with high levels of unemployment, inadequate education and training, and limited opportunities for political spaces. Further, the youths were exploited and used as tools, especially if you look at the political aspect of it. The youth were used as political tools. For instance, the youth for KANU 92, in the Mungiki era, you would see that the youth formed a majority of this political crisis. So another rationale that led to the inclusion of Article 55 in the Constitution was public participation and the recommendation of reform bodies. And by reform bodies, what do I mean? I mean the Constitution of Kenya Review Commission and the Committee of Experts. I don't know kama tumepatana na such terms, but these were bodies that were formed towards the realization of the Constitution. So the Constitution of Kenya Review Commission, in its 2005 final report, you would see that they emphasized youth marginalization, and they also talked about the youth being denied opportunities in employment, in governance, access to national resources, despite them forming over 75% of the population. They also noted that the draft bill of 2002 did not recognize the youth as a distinct category. So then came the Committee of Experts after the Constitution of Kenya Review Commission that prioritized addressing the challenges that the youth faced, including unemployment again, lack of access to relevant education and training, and underrepresentation of these groups. So in response, the Committee of Experts drafted a harmonized draft constitution that proposed measures towards the inclusivity, including the representation of these people in the Senate. So given that, we can see that Article 55 has some terms that I would like to discuss, or rather not because of my time. I will come back to that later. Thank you.
Thank you, Hiltruda, and thank you for how well you're managing time. I know this is a constraint for all of you. You make a fantastic point, Hiltruda, and it's something that I have repeatedly pointed out as a historical fact, which is it is impossible to win elections without youth in this country. I think everyone acknowledges that. Yet, when we look at the face of government, we don't see the youth. So I like to ask this practical question all the time. How many members of the cabinet are youth, 35 years and under? How many ambassadors are youth? How many members of the county government in terms of leadership are youth? I believe when we did our devolution study in 2021, only one person under 35 had ever been elected governor out of 47. The majority of the seats which youth would contest and get was MCA seats, which speaks very strongly to your point of youth being tools for the political class. We know that their energy is useful, their capacity for mobilization is useful, but we don't see them as people who can be entrusted with leadership roles. And that, of course, is frustrating. One of the things which I think is critical to ask, even as we go into 2027, is in light of the shift in the political climate in the country since last year, what does this portend for the youth? It's clear that the cat is out of the bag. It's not going back in the bag. It's clear that because of the youth bulge, because there's so many educated youth who are unemployed, that there's going to be pressure on the government to provide a solution. We don't see any traction by the government towards that. Yet it's not going away. And it's not a Kenyan thing, it's an African thing. So the question that we need to keep asking is, what are the youth planning to do to take that momentum to the next level? And I'll be coming back to that when we do the discussion session. But allow me to yield the floor now to Jacinta. Jacinta is going to speak to us about Article 56, which deals with marginalized communities, and then we'll come back to minorities and marginalized groups, my apologies. And then we'll come back to older persons and open up the floor to the discussant and audience engagement. So Jacinta, if you could, the floor is yours.
Thank you so much, Madam Luciana. Habari ya jioni kwa kila mtu. Article 56 yenye nitawapeleka inahusu marginalized and minorities group. Nikiangalia kitabu yangu nimeandika kwa Kiswahili. Ini ubaguzi na ubaguzi wa wachache. Nikiendelea kuongea utaelewa kwa nini nasema hivi, na nitawaelezea historia ya kwa nini tulikuwa tunataka Constitution of Kenya 2010 ikuwe na Article 56 yenye itakuwa ina empower na kuprotect the rights of the minorities and the marginalized groups. Wanasemanga ukifanya freedom ama ukitaka kila mtu awe huru, the core function of freedom is for everyone to be included. Hii article ukiangalia historia yenye nitawaonyesha hivi punde, utaona kuwa kulikuwa na kitu inaitwa marginalization ama exclusion, na exclusion ni kutengwa. Kulikuwa na kutengwa kwa regions zingine ama communities zingine kwa sababu ya easy reasons zenye nawapea: poverty and economic exploitation, umaskini. Kulikuwa na kitu kama political underrepresentation, na nitaonyesha hiyo tukiangalia political leadership yetu ya country. Kulikuwa na vitu kama limited access of infrastructure na education kwa some areas ya country yetu. So ilikuwa inaleta underdevelopment kwa hizo area. Na hata sahi ukiangalia country yetu ya Kenya, kuna areas zingine zenye unaona ziko developed kushinda zingine. Kuna areas zingine kama uli grow up kwa village kama mimi, ukicompare areas kama Mount Kenya na areas kama West Pokot ama Elgeyo Marakwet, utaona kuwa development azitoshani. So Article 56 ilikuwa inakuja ku make sure kuna inclusion, kuna participation na kuna resource allocation to those areas zenye hazikuwa developed. Kwa hivyo nitawapeleka kwa historia kwa nini tulihitaji hii article katika katiba yetu. Ukiangalia before wakoloni wakuje nchi yetu ya Kenya, tulikuwa tu, for example, Wamasai walikuwa nomadic, so walikuwa wanafanya tu practice yao ya kuchunga ng'ombe, wengine walikuwa wanafanya farming, hatukuwa na haja ya kufanya development, kuwa na roads, infrastructure na kila kitu. But after wakoloni walikuja kusettle in some areas of our country, particularly the areas that are fertile, which form part of Mount Kenya regions. Na kwa sababu ya hiyo, waliweka development in those areas na wakaleta segregation. Na ukisoma kazi ya mtu anaitwa Mamdani, anaongea kuhusu the idea of bifurcated African states, ambapo hawa minorities ukichora kwa pyramid, walikuwa minorities but wali take over the major ordinary wananchi wenye walikuwa chini ya pyramid. So colonialism, in as much as ilikuwa a very short period, na ukisikiza Ali Mazrui pia kwa documentary zake, it's a very short period but it came up with intergenerational things that we are still fighting to this moment. And therefore there was need for inclusion, and because development was already felt in some areas of the country and other areas didn't feel included in those spaces, as the idea of segregation built on by the colonists. The idea is, after Africans walichukua, after independence, era ya Jomo Kenyatta na era ya Moi, kulikuwa na effort, kulikuwa na hope, kwa sababu KADU, ukikumbuka wakati wa independence, there was KADU and KANU, and KADU was of the fear that the marginalized group could not be represented, and to this point, we are still fighting for that. And documentation, na ukiona wana historia venye wali document how we should bring about devolved county resources, utaangalia kutoka kwa constitutional making process kutoka 1999 to 2010. 202 kulikuwa na kitu yenye mwenzangu ame-mention hapa, CKRC report, ilikuwa inaitwa GAHI, the Guy draft. Na hiyo draft ilikuwa inajaribu ku bring about distribution of resources to local levels in 5 different aspects. So kulikuwa na national, provisional, district, location na village. Kwa village ni important kwa sababu inakuja kwa grassroots. Development inakuja kwa grassroots na kwa wananchi. So hapo venye nimesema ni kufanya watu wakwe na participation in parliament, na pia kuleta cultural diversity na ku make sure marginalized groups wanapata infrastructure na their voices are being heard. Bomas draft ikakuja ikaleta 4 of them yenye ilikuwa enough, ili reduce, ikaleta the national, regional, district na local, na ilikuwa heavily borrowed kutoka kwa katiba ya South Africa, na hivyo ndio utaona venye jurist walikuwa wanapenda kufanya kusoma na kupropose ideas zenye zinaweza tusaidia kama country. Then kukakuwa na wako report yenye ilikuja ika-reduce devolution to 2 levels yenye tuko nayo sahi, the county government levels and the national levels. Wako report ya 205 ilileta 3 national and district levels as well. So ilikuja kudilute the system yenye kulikuwa na so much power ukiwa na regions zenye ni 5 than kuwa na regions zenye zitakuwa 2. So tunajua 207 na 208 ilileta a very big history in our country. I'm winding up 30 seconds. So after post-election violence, watu walikuwa nataka kuwa united na reconcile themselves. So there was need to bring inclusion, and after the promulgation of our constitution, we came up with the county level and the county government and the national government that brought about the devolution and the 47 counties that we currently have. And we will discuss later whether this marginalization problem was solved or whether it was not achieved, and what steps we need to take to make sure that we achieve what the drafters of the constitution wanted to achieve.
Asante Jacinta. I think the question of minorities and marginalized groups is a complicated issue in Kenya because there's an intersection of different things that produce marginalization. There's geography, which you've rightly pointed out, a factor of colonialism, that the colonial government prioritized certain areas over others. And so if you're from Kiambu, if you're from Nairobi, if you're from the productive parts of the country, you had a better quality of life than if you lived in the northern frontier districts or the coastal region. So there's also, and this is something that I'm hoping can come up in the discussion, the fact that exclusion in Kenya, just like in many countries, is an intersection of many things. So there's geography, there's political affiliation. For those of us who grew up in the 80s and 90s, tulikuwa tunaambiwa na Moi, siasa mbaya, maisha mbaya. If you don't align with the KANU government, your region gets no development. And then there's also people who are from small communities which didn't get access to political representation. You've talked about inclusion, participation, resource allocation. And one of the things that, and I'll come back to this when we do the discussion section, one of the things that then happened is that there were some communities that never had political inclusion in parliament because they were so small. So Ogiek communities, for example, never had an elected member of parliament. And this is something that the High Court addressed in 2006 in the Lemeguran case. So there's geography, there's age, there's political affiliation, disability, gender. All of these are factors that create exclusion, which is why Article 56 is important. And so if you look at the definition of who is a marginalized group, it's a member of a group which, for any of the reasons in Section 27, experienced discrimination. So one of the things that we must talk about is, even as we are going into the new constitution and we are getting devolution, are these things addressing the factors that cause people to feel excluded? And one of the things which I would have wanted to see more of is a discussion of devolution and political inclusion, and whether these things are addressing the reasons why people felt that they were not a part of the government of the day, they were not accessing resources from the government of the day. But because we will have a bigger session for discussion, allow me now to yield the floor to Joanne. Joanne will speak to the rights of older persons, and then I'll come back. So Joanne, the floor is yours.
Thank you so much, Ms. Luciana. So again, my name is Joanne, and I'm speaking about older members of society, that is Waze, like the older people. And so I'll start with before colonialism. So before colonialism, we know that elder members of society were like a pillar to the community. They were very revered and respected. They were walikuwa watu wenye wanashikilia wisdom, like they knew everything, and they used to think of them very highly. But with the colonial era, we see that we moved from, thinking of elders as top hierarchy to elders as, we've moved on. We are now looking for money. So people are moving from, waiting for elders to give you instructions, thinking of elders actively, to now chasing the money, following whatever the white people are saying, the colonialists are saying. And then we move to post-independence now, when we've gotten our independence, where we completely forget them. Now the economy is now moving, people are moving to towns, and completely there's almost a neglect of older members of society. And this is now where the gap became very wide and very noticeable, that nobody is taking care of older members of society. Unlike older times where they could, like, for example, find food and do things for themselves, now everything relied on money, and they could not, for example, work, and therefore they couldn't get basic necessities to even support themselves. Now this is where we needed a lot of help, especially for the older members, because now they could not be helped. There's no one at home because people have moved. People have moved to Nairobi, for example, to work. People have moved to urban areas, and there's literally nobody. They're usually alone. Now that is where Article 57 really came to fill the gap. So Article 57 ilikuja kusaidia kwanza na kuallow kukubali hao watu wa participate in community. Now watu wazee walikuwa nakubaliwa nao wakuja waongea hata kwa baraza, wakuja wa participate hata na kuvote, vitu kama hiyo. Second ni wa pursue their own development, wakuja wajisaidie, kama ni biashara, kama ni ukulima wafanye. And also wakwe wasi abusiwe, yani wasi umizwe. For example, mnakumbuka kulikuwa na a whole wave ya wamama wazee uliwa na kwa sababu wanaitwa wachawi, si ndio? So when there was this huge wave of mass killings, now that is when the gap, of course, we saw that, hey, there's really a gap here. Like, wapi sheria ya could prevent this? Of course, there's these other sharias like do not murder and other things like that in the penal code. But there's nothing to address specifically mahitaji ya watu wazee. Hakuna kitu nye itakuja ishughulikie watu wazee peke yao. It's usually just kitu inasaidia kila mtu ndio itasaidia watu wazee. So now that is when the old persons bills came in. And e-bill hata mpaka saa hii haijakuwa law, but we know that e-bill ikuja isaidie vitu kama hii. Number one, kulikuwa na prohibition ya abuse. Watu wangeumiza wazee wanalipishwa 1 million ama about 1 to 3 years imprisonment. Also, e-bill ilikuja ikaongeza vitu kama care homes, penye wazee wataenda wakae washughulikiwe as they age, ndio. So it was really important for us to pass this bill, but of course, as we know, imestall, haijaendelea. So imekwama, and we since 2019 haijasonga kutoka Senate, and it is a very important bill because inasaidia vitu mingi venye nimetaja, na hizi, of course, hizi civil societies kina NGEK, kina KNHRC, Helpage Kenya, wamekuwa wakipush isongeshwe, but of course, kila mtu ana complain. For example, counties are saying, mnatusongesha hii bill kwetu, it will require us to now care for the elderly, create homes, build homes, pay them. Of course, in Wajami now, they'll have to expand it, and it's going to cost them a lot. Itawachukua pesa nyingi. Na wanasema mimi sina pesa, hakuna budget ya hiyo. So they are stalling, of course, I wouldn't say purposely, but they are stalling this bill, and it is, of course, of critical concern for us that it moves, but as of the moment, it is still stalling. And of course, another thing that Article 57 provides for is that care should be provided for by family. Now, inasongesha hii jukumu ya kuchunga watu wazee from state na inaongezea pia familia, that familia pia ni mwachunge. And I used to think about this na kufikiria mara ngapi unaenda kuona, for example, wazee wenu, like your grandparents, unaenda lini? Of course, most of the audience, you'd be thinking, oh, maybe Christmas time, that's like once in a year, maybe even, let's say, twice. And what of all this time? What is happening to them all this time? You know, and of course, ni wote mmehama, mko Nairobi, there's nobody, Ushago, they're alone, and we don't really care. And of course, we think, okay, Jamii is coming to play a role. They're getting cash transfers of about 2,000. But let's really, tufikirie kabisa hii 2,000 inawasaidia aje. You know, hii 2,000 is a very, very little amount. Thinking about it, 2,000, you'd pay for food, you'd pay for maybe rent, if anything, your healthcare, you will pay SHA. You know, hii pesa ni kidogo sana. And for example, Sazile, that the audience member said, yes, mzee, but si mzee sana, but she uses maybe even this money to pay for other people who are living in their house. And yeah, so I think it is very important for us to discuss this, and we'll get into it later. Thank you. Back to you, Ms. Luciana.
Thank you, John. I'm just looking at Article 57, and I'm just thinking about the thing which for me underlies my analysis of Article 54, 55, 56, 57, which is a question of dignity. You make a reference in your commentary about the importance of, and again, this is the language of the Constitution, living in dignity and respect and free from abuse. All of us will grow old by the grace of God. If the mean average age continues to retain as it is, all of us will get to at least above 57. And so the question will mean we will all then have to grapple with what does it mean to live a life of dignity as an older person. The reason why it's important to think about this as an issue of dignity is we think about older people as people to be managed. Again, going back to the question of disability, this welfare model, it is not dignifying. And that's why when we talk about older persons in society, we must go back to thinking about the contributions of older persons. When we think about the democracy journey in this country, you cannot talk about the return of multi-party democracy without talking about the women who went and stayed at Freedom Corner in 1991 for the release of political prisoners. They were not youth, they were not young people, they were women who were elderly. And what they stepped into as elderly women is the idea that age carries weight in this community. And if an older woman does an act such as stripping, it invokes a curse over the society, and that is something that can be taken seriously, and indeed it was taken seriously. So when I talk about the importance of dignity, it's important to not look at older people as people to be managed, which is what, unfortunately, society now does, as you're saying. Let's put them in homes, let's give them a stipend, and think about what does Article 57 mean when it says they fully participate in the affairs of society. Other jurisdictions are grappling with the question of whether we should take away voting cards and driver's licenses for older members. It's not a Kenyan problem, luckily. Those are first world problems. But we must keep asking, what does it mean for us to have full participation in all the affairs of society of older persons, older members of society? What does it mean for them to live in dignity and respect and free from abuse? It's not for us to determine what dignity is for them. It's for us to listen to them and ask, what would they want to do to live a full life, including political expression? A lot of the focus right now is on what the youth want. Has anybody asked older members of society what they think about the future of the country? We just assume they got to a place where their participation in governance is no longer necessary. Let's focus on the next generation. Why? They're affected by policy just like any other person. So even as we have this conversation, dignity must underlie the way we do policy making, the way we make decisions concerning older members. But as I keep saying, it enlightens self-interest for us to look at older members of society's welfare, because we will all, by the grace of God, be older members of society. I know we only have 20 minutes, so I'll just spend 10 just giving my feedback on each of the commentaries. And then I'll open up the floor for audience engagement, because I'm sure the audience would like to tell us what they think about Articles 54 to 57. So I'll just go back to what Ekisa and Jerry prepared, which is the write-up on Article 54. I think the write-up is good. It does a good job of tracking the history, as I said. I think what I would have wanted to see is a greater reflection of what does it mean now that we have a new law. I feel like the way in which the commentary has addressed the 2025 Act is a bit peripheral. So, for example, when the Act now talks about equality before the law, what does that mean for people with disabilities? And we must always remember that not all disabilities are treated equally by society. For a long time, whenever we hear disability, we think about physical impairment, something we can see, a visual impairment, a hearing impairment, a talking impairment, a physical deformity that we can see. And we rarely give attention to the fact that there are people among us whose disabilities are not visible to the naked eye. People who have psychosocial disabilities, we rarely ever think about what they need and how we can support them. This law is now bringing up the issue of equality before the law, and another important concept, which is supported decision-making. Just because you have an intellectual disability doesn't mean you have no capacity for making decisions and determining the course of your life, what we call independent living. I would have hoped that there would have been a greater discussion of what does this mean for other categories of disability, because this Act does a good job of going beyond what we have always looked at, which is physical disability. If you look at the 2003 Act, there was a lot of focus on adjustment orders, advising the minister on what needs to be done to make room for people with disabilities. The focus was primarily on the physical disabilities. But this act does a really good job of extending protection for all persons and recognizing that concept of equality before the law. I would also have wanted to see, and I'll throw this back to you for the audience engagement, Ekisa and Jerry. Now that the Act creates or reformulates the National Council of Persons with Disabilities under Section 39, if you look at the old law only gave functions to the National Council of Persons with Disabilities. But the new law has both functions and powers of the National Council of Persons with Disabilities. Previously, the only power that the council had was to issue adjustment orders. Your building is not compliant, please revise it. But now we are seeing a shift from, we are not just advising the government to help people with disabilities. We have the power to enforce it. We have the power to do an audit. We have the power to issue penalties for institutions that don't comply with the law. What does that mean going forward? And even better, how do we translate that for inclusion in other spaces like the political space? Because it's not enough for the law to exist. We must talk about how will it be enforced and how do we give effect to what we talked about earlier. Inclusion, participation, resource allocation. For a long time, the government always said we don't have money for including people with disabilities. And that's why when the Persons with Disabilities Act began to be drafted in 1992, it took 11 years to get a law, 2003. So the government will always have an excuse for why we can't do what the law requires. So what is the opportunity that the newly formulated council has from shifting from an advisor and a regulator to an enforcer, an enforcement agency? What does that mean for people with disabilities going forward? And how does that translate even to other sectors like politics or in elections? I would also like to see how do we address the resource question. As I said, the government has always used resource as a reason for why we can't do certain things. I'll give practical examples. In countries like Mozambique, people with visual impairments vote using what we call tactile ballots. They have ballots which are printed in Braille. It just requires the government to make a realization that there are people who don't get to vote on their own unless they're assisted, and to invest in that. So how can we use the council to address issues of inclusion, and how do we overcome issues of resources as we go forward? But there's something that I also wanted Ian to think about alongside Joanne, which is that disability and age are related. Why do we say that? Old people are very likely to also suffer some form of disability, whether it's physical because of aging-related complications like arthritis, which affect mobility. It is very likely that one of the contributors of disability is age. Now that you have a National Council for Persons with Disabilities that is going to be dealing with those questions, and now there's an older persons bill that's going to be coming to address the issues of older persons. How do we avoid duplication of roles? Because what ends up happening is when you have duplication of roles, people don't find help. They keep being shuffled from one place to another. Same issue with children. So if you look at the Children Act 2022, children with disabilities are entitled to free medical care under Section 20 of that Act. There's a National Council for Children's Services under that Act. Between the National Council for Persons with Disabilities and the National Council for Children's Services, who should be the one that monitors that children with disabilities get free medical care? So there is likelihood of duplication of roles, meaning no one gets helped. And I'll come to youth because this is something that I know has happened to youth with disabilities. We have a youth fund. For a long time, youth with disabilities would try to access the youth fund and they're told, if you're disabled, go to the council. So I would like you to think about, even as you're doing your individual commentary, how do these different elements of marginalization intersect? Because the truth of the matter is there are many people who experience marginalization on multiple fronts. As I had said earlier, you're a woman, you're a young person, you're disabled, you're from a marginalized community. All of these things lead to your experience of being excluded. For the youth, as I said earlier, I think the commentary does a very good job of doing a historical analysis and this question of youth being used as pawns during elections, but nothing else. And the paper also is very good with addressing this paradox of you have many youth and they're agitating, but they're not taking part in processes like elections. And they're also heavily involved in other issues like activism, like what we have seen with the finance bill protests. So how do we capitalize on this energy for activism to ensure that the full intention of Article 55 is realized for the youth? So I think the paper does a very good job of connecting the current political trends with the constitutional context, but it's important to also address why despite the age, why despite this energy that youth bring to the context, why despite their numbers, we are seeing a lot of gaps with giving youth space for leadership, giving youth room for inclusion at all levels. As I said earlier, we don't see youth in leadership, we don't see youth being involved in policy to the same extent as their numbers would dictate. It's also important to keep thinking about how do we capitalize on this for other sectors, like politics, like decision making at all levels? It's not just politics that we use for decision making. How do we create avenues for youth to be involved in making decisions without waiting for elections? For Jacinta, I thought the marginalized paper was very good in terms of how you went into the history and the jurisprudence. Again, I think we would want to see why are there so many gaps when it comes to implementation of the rights of minorities. I would have wanted to hear what is devolution doing well and what is it not doing well, because some things devolution is doing better than others, but we still don't have as much impact as we would like for marginalized groups. So why aren't quotas working as well as they should work? Are we having budgetary allocation for marginalized groups? Because the idea of devolution was to bring decision making and service delivery closer to marginalized groups. What is the problem with budgeting? What is the problem with audits, if at all? Are they being done? Are we assessing how well we are doing with social justice? If not, what can we do better going forward? For Joanne, I've already spoken about the issue of seeing the linkages between disability and older persons. It's good that you've addressed the older persons bill. It would be good to also talk about what is missing in the political economy that keeps us from implementing this bill. How can we overcome that inertia and get the bill passed? And then you've also talked about the issue of older women suffering more than other categories of older persons, which is true. But there's also this question which I want you to also address, which is the fact that this question of intersectionality. Older women are also doubly marginalized. There are certain needs that older women have which don't get taken care of in the broader context of older women. And when we talk about the overlap with the functions of the National Council for Persons with Disabilities, I'd want you to think about how does the council specifically address the issues of older women. Also, I'd like you to think about this question of Article 57. What does it mean for older persons to have electoral participation? Do we need to put special mechanisms in place for age-related barriers to voting? I think it's something that we never hear enough about. And the same thing with devolution. Is there something that devolution ought to do for older members of society that it is not doing? I know from county to county, performance is different. I know Western, for example, Kakamega County has had very good policies for protecting older persons and putting them in older persons' homes, but not all counties are doing the same. So how do we ensure that protection of older persons is working well across the board? Think about things like, should we be thinking about universal health care for older persons? How do we think about planning at the budget level better for older persons, so that it's not just a welfare thing where we give them some kind of funding, but also we are also thinking about how we involve them in decision making. Then give us a way forward. What should we do to unlock where the bill is? Should we be thinking about litigation? Should we be thinking about activism for older persons? Should we be thinking on focusing on the county instead of the national? As you said, there's this tension between national and county. Where should we be focusing our efforts going forward? So those were my reflections when I read the commentaries, and I want to now open up the floor to the members of the audience for question and answer. We have about 10 minutes for this. I want to open up the floor to question and answer. And of course, the panelists can also contribute based on what I've said. So I'll yield the floor back to you on the ground.
Thank you, Luciana. I think the comments you've given will go into the written work. So part of the conference is also a validation for the things that are being written. So your comments, some of them will make it to change vile kitabu ambacho tunatayarisha kitaandikwa. Sawa. Kwa hivyo sasa ni muda wa maswali. Kama unajitambulisha kama mtu ambaye anatoka kwa kitengo kilicho ni si kitengo, group iliyotengwa kama wazee, wanawake, mtu mwenye ulemavu, utapatiwa kipaumbele. Tunachukua tu maswali matatu. Nimeshaona mkono mmoja. Wewe si mlemavu, wewe si mwanamke, wewe si mtu mwenye si mzee. Kwa hivyo acha nimechukua mzee mmoja pale. Mzee ni mtu ambaye ako na umri mkubwa kuniliko. Kwa hivyo unataka pia kuongea? Tuko na mwanamke ama mlemavu ambaye angependa kupatia maoni yake au swali. Utakuwa wa pili. Wa kwanza ako pale nyuma. Kuna mlemavu? Mtu mwenye ulemavu yoyote? Okay, basi kuna mwanamke ambaye angependa kupatiana maoni yake? Yoyote, natural ama accidental. Umesikia kwamba Madam Luciana amesema ya kwamba kuna ulingano katikati ya uzee na ulemavu, ya kwamba kuna ulemavu ambao unakujanga wakati wa uzee na haijaandikiwa vizuri. Pale nyuma yule mzee ambaye, yes, ule ndio wa kwanza. Wa pili ni mzee huyu. Ninataka kupatia nafasi ya mwisho kwa mwanamke.
Thank you very much. I really enjoyed the conversation by Madam Luciana. I think I'm very grateful for this actually eye-opening session. And my concern was about what the panelists had already offered us. I think they were given direction to give us historical perspective. And she came out, Madam Luciana came out very clearly that where do we go from here? And I think the same thing I had asked earlier is that it's critical reflection on the constitutional transformation in Kenya. So we are saying, like, if we are 15 years old, when do we say we are mature enough to actually have established a complete realization of the Article 54 to 57? That would be my very clear, like, we have the young brains working on this, but do they really have goals? Like, let's give ourselves, by the year 2030, we will have actually realized 80%, so that we don't actually look at a welfare society. We are looking at a participatory society. If we are saying about the youth being in leadership, at what stage is it driven by problems? Or is it a dream that they will articulate the ideals of youthfulness? Are we talking about disabled or women who are going to have ideals of representation? I think the older men are not looking for welfare. They have their money, they have something called, they have wisdom. The respect is what they're asking for. It's not really a welfare. So sometimes we have to look at it from that perspective, because Kenya is now going towards establishing a performance society rather than a conflict society. Thank you.
Kwa majina ni Anton Maina kutoka kwa shirika la Speak Kenya. Mimi nataka kuongea kwa sababu kuhusu wazee. Na nasikia dada yangu amesema pale ya kwamba anataja sana older women. hataji wazee. Na wacheni niwaambie wapendwa, kuna shida. Mama anatoka Nairobi, anatoka kijiji, anaenda kwa msichana Nairobi, anakaa Nairobi, mpaka mzee huko amewachwa na mbuzi na kuku. Yes, scenario ya kwamba mama alienda akakaa Nairobi, mpaka mzee akaanza kuuliza, akapeleka kijana kwa chifu, amenyaganywa bi. Na it happened hata kwangu, nimepeleka kijana wangu kwa chifu. Kijana anakuja sijui anaongea nini na mama. Sasa nikaanza kuangalia, hata mimi mwenyewe nikaanza kuona nanyaganywa. Sasa nilienda kwa chifu nikamwambia nimenyaganywa bibi. Sasa tulipoenda kwa chifu, sasa wanagojea mwenye amestakiwa, kijana wamekuja na mama yake na bibi yake. So niliulizwa wapi mstakio, nikasema ndio ule. Kaya kijana kashindwa amestakiwa na nini. Sasa nikamwambia huyu ameninyang'anya bibi. Kwa sababu hata wakati nakuja kuangalia issue zangu, hawa wamama wametunyang'anya in fact. So alisema yeye ni mama yake na mimi nikamwambia ni bibi yangu. So na mimi sijanyang'anya yeye bibi yake. So issue ya kwamba wazee wanaumia, kwa especially wazee. Wamama hawana shida, hata anaweza kaa hata anakuja kwako anakata ni mama yako, anakaa wiki 2, wiki 3, hata analala hapo tu na ati anachukua kale katoto kadogo, sasa anakula ile chakula mzuri. Naye mzee huko anawachwa na mbuzi na kuku, hata shosho anapiga simu kwa mzee, na kuku iko mzuri. Sasa nani alikuwa anapikia yeye? So kuna issue ya kwamba alafu sasa hii issue ya tunaambiwa ati 2,000. Wazee wanapewa 1,000 ngapi? Na juzi nikaona manipulation na wanasiasa hapa na town. Mwanasiasa ameleta wazee na walemavu, wakafanya mchango hapa ati ni empowerment. Sisi wazee wataki empowerment. Wana empower wafanye kazi gani? Ni wapewe haki yao na sio 2,000, kwa sababu hata 2,000 wengine ni wagonjwa wa sukari, wengine ni wagonjwa wa pressure. Sasa unaona hiyo 2,000 hata inunui dawa mara safari 2. Yeah? So unakuta kwamba sasa kulichangwa milioni, it was 60 something, it was milioni sijui 7. Saturday after hiyo wanapewa 2,200. Hata hizo pesa zingine waliambiwa ati zimeenda namna hiyo. Kwa hivyo kuna mambo ambayo serikali inatakiwa iangalie zaidi, hasa wache hiyo, hata ukimpatia 2,000. Na kuna dadangu amesema pale 2,000 itafanya kazi gani? Hata itakaa kwa muda gani? Haya, wewe naye kijana unakuja unapatia mama 5,000, mzee anaambiwa shika 1,000. Alafu mama atapenda nafikia ile 1,000 iko na mzee ati hakuna sukari na amewachiwa pesa nikija. Hapo kunatakiwa kuangalia vizuri. Asante.
Okay. Luciana, kuna swali nyeti hapo ambayo tunakutupia wewe kama expert in this area. Utuambie mbona hamuangalii maslahi ya wazee wa baba, si ndio? Wakongwe wetu wa kiume, mbona hamuangalii maslahi yao, mnaangalia tu ya wamama na wazee wanabaki na kuku na mbuzi, si ndio? Okay. Sawa sawa. Swali la mwisho ama tuchukue tu haya mawili? Hapana, nilisema ya kwamba swali moja lazima liende kwa mwanamke, specifically an older woman who can give us a question that she has found interesting from this session. Anybody?
Wacha niongee kwa sababu Kiswahili ni mbaya, lakini sijui itasemaje. Yangu ni kuelekeza kwa wakati wa walemavu. Sasa niko na mwalemavu lakini ametengwa, hajapata hata hiyo pesa ya kusema ati inasaidiwa. Akienda kwa mahali na takikana kupewa pesa, anaambia wewe sio mbaya, lakini mkono wake akui nini na mguu. Sasa yani upande mmoja ashiki kitu na mguu na nini. Sasa unajua Kiswahili ni mbaya. Sasa ningeongea vizuri, ndio nimeambia hao majirani yangu nitaongeaje, na niko na mwalimu.
Tuko na watu wa kutafsiria hapa. Ongea tu
na Luka.
Ndio.
Oh. Mite lakwet notinye ne mwalimu yotindo lo. Sijui kama nani anasikia kikale kabisa.
Zita anasikia.
Na ako na watoto lakini akienda mahali ile na si ndio? Kongete ako msichana lakwet si chepto kotindo lo au kikitun ine lakini bokiti simbondenyin matindo kimnotet kora kotam motoreti lakini angwo kibore social ana kibore ano tam kobendi kelenjin meya missing kuna kole miten cheyachen soiti ketoreti choto kole ketoret choto sasa konini choto nanya tapata akilini nani mwalimu kilione nani.
Mama anasema akona msichana mlemavu mwenye ameumia
na wengine akalak chechangis kora akiche.
Serekot?
Mama yani si ajirani akiche kalak.
Ako na watoto walemavu wenye mmoja ameumia, so kwake akipeleka mtoto wake kuna ulemavu funds, anaambiwa aja meet the threshold ya kuwa mlemavu. So yeye kama mama anaona anasumbukana kwa sababu people with disabilities need extra care and attention, but if the society is going to exclude the threshold that you're not mlemavu enough, itamsaidia aje? Hiyo ndio swali yake.
Okay, asante. Kwa swala la ulemavu, tajaribu kujibu swali hilo. Kweli sheria inasema kwamba walemavu wana haki ya kupata afya kama tu sisi wengine. Lakini kuna council inaitwa National Council for Persons with Disability ambayo hata mwalimu amekuwa akiongelea saizi tu ya kwamba kulingana na sheria za nyuma ya mwaka 2003, hiyo council ilikuwa na kazi ya ku-advise on the implementation of these rights. Lakini sheria hii ya mwaka wa 2025 imepatia hii council power ya ku implement these rights, yani imeipatia nguvu ama ruhusa ya kuhakikisha kwamba walemavu wanapata haki hizi. Ni kweli pia serikali mara kwa mara inasema kwamba haina pesa, lakini wanafaa kutuma pesa kwa the National Funds for Persons with Disability ili waweze kupata haki hizi. I'll also invite mwalimu to add on that. Yeah.
Thank you. I think Mama is what we call in the disability rights movement, and maybe someone can also help me to translate. My Swahili is not capable of delivering this. Mama is what we call a caregiver, and the Act for the first time provides for certain protections for caregivers, because the thing with disability is it doesn't just affect the person who is disabled, it also affects the person who is required to take care of them. And so the Act does two things which are very important. Number one, the Act gives all persons with disabilities right to free medical health care, Section 24. Number two, it empowers the National Council to make regulations for the realization of certain things, including if a person is taking care of a person with disability and they really have no money whatsoever to give them the medical care which they need, they can get an exemption for their medical care from the government. And the third thing is they also have tax reliefs for importation of certain medical equipment. Now, the problem has always been money. This access to free medical care is only for public health institutions. Now, we know that in Kenya, there's always been this tiff between the national government and the county government because health is a devolved function. And that means money has always been difficult to allocate when it comes to public health facilities. So in paper, there is actually a solution to that problem. The problem is practice, because even if you create a right but you don't allocate resources, then caregivers and people with disabilities don't get access to what the law enables them. Which is why, and I'll go back to what I had said earlier, the question we must ask now is, how are we capacitating the National Council for Persons with Disabilities to give effect to the very good provisions of the law? Because the law is trying to address those problems, but without the capacity for enforcement and resources, those things will not be realized by people with disabilities and their caregivers. But the Act does a very good thing in recognizing people like Mama, who have the burden of caring for people with disabilities without resources, and who are given arbitrary assessments as to their capacity to access the resources and the facilities which the government has made provision for. I don't have a solution for the issue of older men, but this is what I think happens. When it comes to women, women are always considered, and this is something that even the African instruments do, women are always considered within the context of the family. And so when it comes to allocation of resources, people always think of, if I'm giving a woman, I'm not just giving the woman, I'm giving her households. And that dictates how we deal with women. It can be a good thing, can be a bad thing, as the contributor was saying. So I think the question we need to ask is, how do we change the orientation of society? Because it's not a legal problem, it's a societal perception problem, that a woman doesn't just exist for herself, a woman exists for her family, her society. And so we capacitate her with that in mind. Does that lead to neglect of both the boy child and the older member of society? Possibly. So the solution is not to take away the support to the girl child or the older woman. The solution is to ask, how do we shift the necessary support to these members so that they also feel equal in dignity? Remember, the concept that I keep saying should underlie all of this is dignity. Everyone is entitled to dignity. Whatever we do when we deal with anyone who's categorized into Articles 54 to 57 must give effect to their dignity as a person. Because of time, allow me to end this session and give the floor back to our moderators, and to thank every one of you for your participation. I'm hoping you found the session useful, and I wish the authors all the best as they revise their commentaries. Asanteni sana.
I've been asked to translate what she said. So sheria inatoa huduma ya matibabu bila malipo kwa watu wenye ulemavu. Hata hivyo changamoto iko katika utekelezaji, kwa sababu baraza la watu wenye ulemavu, that council yenye iko in charge ya kuangalia sheria, haijapewa rasilimali ya kutosha, haijapewa pesa ya kutosha, na haina budget ya kutosha. Kwa hivyo Madam Luciana amepatia hawa wenye wanaandika hiyo changamoto ya kuangalia ni wapi ambapo tunaweza fanya ili kuangalia jinsi ya kuziba pengo hilo. Sawa? Okay. So I think that will also answer your question, which is that there are implementation gaps, and we need to see where we are going from here and how soon it can be done. I think that's what the gentleman at the back asked. So please, when you're finishing up your research, put that in as well. Okay? Please join me in giving them a clap as we thank them so much. We want to bring in the last session. Now, this last session will be a bit disadvantaged. We will be reducing the time significantly. I don't know if Ms. Kinama has joined. The next panelists, please come up. As the next panelists come up, they need to mentally prepare themselves for having an extremely short session. We'll probably only have about 30 minutes or 40 minutes. So 20 minutes for your discussions and 10 minutes for questions. Is Emily Kinama with us online?
Yes, I've joined somewhere.
Thank you, Emily. I first met Emily in 2012. Yes, 2012, just before we went into elections. I have known her through that time to be a brilliant lawyer. She's a distinguished human rights lawyer. She's known for her strategic litigation work, an unwavering commitment to constitutionalism and public interest law. She is the head of strategic litigation at KATIBA Institute. And so it's quite fitting for her to finish our sessions on this today. She has done her Bachelor of Laws and her Master's in International Laws from the University of Pretoria in South Africa. And in 2015, she's also worked at the Supreme Court, where we worked together as a law clerk. After that, she went to the Constitutional Court of South Africa and served for a while as a law clerk. And her performance during this exchange was internationally recognized, reflecting her legal acumen and dedication to justice. She joined KATIBA Institute in 2017 as a litigation and research counsel, and she has participated in certain landmark cases. In the morning, you had a keynote speaker talking about Mitubel, which was the case about illegal evictions from government land. And she was one of the lawyers who led the team that litigated all the way to the Supreme Court. And she was able to get a quite good victory for the poor people, poor squatters in this country. So she has done a lot of work in strategic lawsuits against public participation. So there are some lawsuits that make it so that there are organizations, to stop the organizations that are fighting for the community to actually do their work. Mtu anaenda kotini kujaribu kusimamisha kazi ya community-based organization ili wasiweze kufanya kazi yao. She is a prolific legal scholar and educator, and her career reflects a deep belief in the transformative power of law, not just a mechanism for justice, but a means to elevate the voices of the marginalized and safeguard democratic freedoms. She'll be leading us through this last session, where she'll be looking at Derek Kipto, we'll be looking at slavery and forced labor. Tracy Jerop will be looking at privacy. Melissa Mungai will be looking at state of emergency. And at the very end, Victoria Oguchuku, who is our first Nigerian student here at Kabarak Law School, is coming to tell us Kenyans about our own Kenya National Human Rights and Equality Commission. And it will be very interesting to see how she views it as a foreigner living in Kenya. Okay, excellent. Please, Emily, take the floor. As I said, we apologize so much. We are compressing your time. And we will ask everybody to just then think about what's the most important thing you'd want us to leave this place with. Okay? Thank you. Emily, over to you.
Thank you very much, Samuel, for that introduction. It's good to see you after a long period of time. And this, I'll go straight into the panelists and the discussions that we're going to have. I know we are the last, and so being the graveyard shift is a bit difficult. So I pray and I hope that you will bear with us as we discuss these very important provisions in our Constitution, some which have been used and some which have not really been used as much, and some which might be violated and you're not even aware they're being violated. So I hand over to the first panelist, who is Derek, and we have been told that we have 20 minutes in total for all the panelists. And I think for you, this is a quick baptism by fire of appellate litigation, both at the Court of Appeal and at the Supreme Court, where you have literally 5 minutes to break or make a case that will eventually or essentially even change policy. So as Samuel has said, you have to think through what is very critical in terms of your paper that you would hope people would learn from. Over to you, Derek.
Thank you, Ms. Kinama, and thank you, Mr. Ngure. So my article is on Article 30 on slavery, servitude, and forced labor. So when you think of the idea of slavery, you think of, chains and shackles. But in the modern day and age, slavery takes a different form. You think of slavery in the form of, maybe labor laws or labor-related matters, where someone is, working in an environment where the conditions are so poor, they're not even getting paid. I think in Kenya, something that most people can relate with is, or maybe something that people have heard is this story of people going to the Gulf, that's Saudi Arabia, Qatar, to look for job opportunities, only to end up in such degrading areas or places of work where they have no resting hours, no food, no pay. We have even cases where people are stripped naked and beaten so that they can provide labor. And that's the form that slavery takes in our modern day and age. There are even other avenues of child labor. That's a form of, falls under this category of Article 30. And so these are the aspects that modern day slavery looks like, even sexual slavery. We have this idea of servitude. So servitude is something that we were discussing with my co-panelists, trying to find a definition of what servitude is. And some of the UN reports show that servitude is linked to cultural ideologies. This idea that as a woman you need to serve your husband in a certain manner. So these are the things that take form, that slavery takes form in our modern day and age. So I think those are the main idea of understanding what slavery is. Maybe to a communal audience, the idea of slavery is utumwa. Unafikiria mambo ya utumwa ya unafanyishwa kazi ya utumwa bila malipo na mama, kazi ya kulazimishwa. Hiyo ndo jambo la kipengele la 30 nilozungumzia. Just to keep on time, I think I should pass through, then maybe Ms. Kinama, then back to Trace. Thank you.
Thank you so much, Derek, for that short and sweet description of the provision on slavery, servitude, and forced labor. And what it brings to mind, if you all remember the story of 2nd May of 2025, when a UN judge who's Ugandan, based in Uganda, brought someone over to the UK to live with her and work with her, but subjected her to conditions that meet the merits or the definition of what slavery is. So more often than not, we need to understand what the legal definition of slavery is, what it is in terms of servitude, and what it is in terms of forced labor, because all those three are different, so that we don't have a situation it is forced labor and not slavery, so that we are able to understand what are the differences between these three. And I know that Derek will cover that within his discussions. He's also brought out a very interesting issue in Kenya where we talk about issues of human trafficking for the purpose of work. And more often than not, we think we ignore issues such as children being brought from the village to come work in your homes as labor, free labor, cheap labor. And we have to think very keenly how slavery, servitude, and forced labor is intertwined with child trafficking and human trafficking. Essentially, what are the dynamics that go into defining what these different violations are? And we need to think about it in terms of you who is sitting there in this auditorium. Do you have someone who is sitting at home or working for you at home? And perhaps the conditions within which you're putting them are equal to slavery, servitude, or forced labor. I leave that open as I hand over to our second discussant, our second contributor, who is Victoria, and Victoria will be discussing about the Kenya National and Equality Commission. Please take over the floor, Victoria.
Habari zenu. Okay, maybe this is the only Swahili you hear from me today, but yeah, it's an honor to speak to all of you about what I think about the Human Rights Commission in Kenya, and because of the time constraint, I'll be very brief. So as she introduced, my name is Victoria Gochuku Okeke, a fourth-year student of Kabarak University. So because of time, I had quite a lot of things to say, but the main thing that happened from the 2010 Constitution, which we are commemorating, its 15 years of existence, this period, is that the Human Rights Commission was now recognized in the Constitution, because pre-2010, initially it was just a directive of the executive. At the first time it was created, it was just a part of the KANU, which was the leading political party at the time. Then from there, it became a standing committee, and from there it was just in a statute. So in as much as the Paris Principles, which is the main principle that regulates national human rights institutions, says that it should be recognized either in an act or in the Constitution, I think the Kenyan situation has proven that being in an act is not really sufficient. I think the constitutional entrenchment really helps, in the sense that it maintains it, it makes it to just remain there, because one of the issues which the Human Rights Commission faced pre-2010 was that at some point, because of the kind of things they do, trying to investigate human rights violations, even when it has to do with the government, at some point Parliament tried to repeal the establishing statutes. But then now that we have it in the Constitution, it's not something that someone would just wake up and try to disband. So I found that as the most important thing that happened to National Human Rights Commissions in Kenya post-2010. And so now, how they exist in the current regime, following the provision in sub-article 4 and 5 of Article 59, where Parliament was given the power to disband them and create successor commissions, thereby creating the Kenyan National Commission on Human Rights, the Commission on Administrative Justice, and the National Gender and Equality Commission. So now these commissions, they have these things, but interrelated duties, and I think, which is, I think one of the key points from what I got is that they should work hand in hand, because one of the criticisms which came up is that sometimes they tend to disagree. So, okay, maybe not necessarily in this very situation, but the previous discussant was talking about how sometimes when duties overlap, it's now left alone. It's like, okay, it's your turn to do it, so let's leave it. And then at the end of the day, it ends up not being done. So sometimes when there is an overlapping obligation or duty between these institutions, they end up not even doing any of them at all. So just the point that they need to work hand in hand as opposed to working as though they are different, so that in as much as they have different duties as successor commissions, they should ensure that they actually work hand in hand when necessary. So quickly, in terms of whether I think they are working, I actually think they are. But then, of course, as we are reflecting, it's something that we should also look at. So what are they doing right? What are they yet to do? What can they do better? And I think this is more of a reflective article for all of us, so that I'm looking at it from the point of, at the time when this commission was created, if you read the CKRC report, to the Kenyan people, they wanted the commissions to serve as a bridge between them and the government. So even to you who is seated here, do you think the Human Rights Commission is serving as a bridge between you and the government? They wanted a commission that would enforce their rights. Do you think they're enforcing your rights today? They wanted a commission that would ensure that the rights of women and children, marginalized groups, and all the things that we've discussed before now are being protected. Even you who is seated here, do you think they are doing that work? And so with that, I feel like we should just, I think we should look at inwardly what we can do in order to help these organizations, because these commissions, because when we look at the kind of work that they do, it's really a delicate work. And when we look at their challenges, there are things like funds, which most of them is usually attributed to the government, because looking at how serious what they do is, and how sometimes even the human rights violations that are being talked about, the government has one or two things to do with it. So even the government sometimes tries to cut their funds and all that. But then even for us as citizens, even for you as citizens, what can you do even in your corner to help them? So for example, for the NGEC, so for example, for the National Gender and Equality Commission, they work on things like GBV. So for example, even small things like going to report gender-based violence cases to them could help a lot. And with that, I pass over to the discussants to continue from there. Thank you.
Thank you so much, Victoria. I think I was thinking through the time we have, and I wanted to hand over to our next participant. I've been taking notes, so I think I will discuss after all the panelists because of time. I will like to hand over to the next participant who will who will discuss privacy. Over to you, Tracy.
Hamjambo. Kwa majina naitwa Tracy Jerop na I'll be discussing the Article 31 right to privacy. Sasa kwa maana naona nimepewa wakati mdogo sana, I'll just give very few points and I'll start with, in terms of history, the only thing I'll mention is that the right to privacy has always been in our constitution. Imekuwa kwa hii katiba tangu 1963 mpaka post 2010 mpaka katiba yetu ya leo. The main difference that we have with this right to privacy is how it has been implemented by the courts. That is, vile ambavyo koti imekuwa iki-handle this right to privacy. So pre-2010, ungeona that the right to privacy that was protected was the right that was in relation to property, where you'd find that, for example, tuseme askari akuje kwako, achukue vitu zako bila warrant, and then uende court ingekupea compensation, because there your right to privacy has been violated. And then post-2010, with the enactment of the 2010 Constitution, we find that the right to privacy, sasa ikaanza ku lean more towards things like the right to privacy of your information, where we find that, for example, kama mtu sai akuje and then anakupiga picha, and then aende aitumie kama advertisement ya graduation ama for something else for their company. Hapo unaweza enda koti and then utapewa compensation because your right to privacy has been violated. And these are the types of cases zenye ungepata kotini hapo from 2010 to 2015 mpaka wa leo. Lakini kufikia leo, now with the increase of technology, sai kila kitu iko kwa internet, everything is digital. So now the right to privacy has started to look different, where the main thing that is being protected is your data. Yes, your online privacy. And in this respect, I'll give one example, kama the huduma number thing. So there was the huduma number case where the High Court declared that the collection of this data for the registration of the huduma number was held to be unconstitutional. Now, with regards to this example, the High Court held that the huduma number registration was unconstitutional, and I'll major on two reasons. The first, ilikuwa because of lack of public participation, and the second was because of collection of sensitive data. Sasa kama biometrics yenye unaambiwa enda weka fingerprint and facial recognition, vitu kama hizo. So that is what privacy looks like today. So seeing as naona ni kama my time has already elapsed, the main thing that I would like to leave with the audience, ningependa kuwauliza, tunachangia kivipi kwa kukiukwa kwa this right to privacy? Kwa sababu kama for example hii huduma number, wengi wetu hatukuwa tunajua hii huduma number ni nini. Lakini baada ya announcement kuonekana Citizen, actually hivyo ndio mimi niliona, na mimi ni a student of law. Niliona tu Kwa Citizen, President amesema, usipo register for your huduma number, you will not have access to certain services. And this is something we saw across the country. Very long lines of people wanakuja kuregister this huduma number. And throughout that whole process, when you are giving your data, unapeana your ID number, unapeana wealth declaration, unapeana your fingerprint, you don't even know, you did not know that during this whole period your right to privacy is being violated. Sasa ningependa tu kuhimiza kila mtu hapa wanze kujiuliza before upeane your data, your ID number, ujiulize kama is my right to privacy being protected, or am I contributing, ninachangia kwa kukiukwa kwa my right to privacy. And how this looks like, I'll give my final example, then I close. Ni kama during the maandamano protests, 2024, where we find that kulikuwa na watu walikuwa nasema atisa the location that the people who had stormed parliament, for example, ati wanatafutwa and their location is being found, and then police is storming and abducting them and taking them. You see, now here we see a clear example where the right to privacy has been violated and what it looks like, such that the government can track your location and your communication. Seeing as my time is up, it has been a pleasure, and I'll pass it back to the discussant. Thank you.
Thank you very much, Tracy, for that background on the right to privacy. I want to hand over now to Melissa, who will discuss state of emergency.
Thank you. Good afternoon, or is it good evening? Habari zenu. Amkeni. State of emergency, Article 58, as Emily said, is rarely used. I don't know whether people have ever heard of that in the Bill of Rights. Is there a right to a state of emergency? So even where it is in the Constitution, is already a statement to start making. But the thing that comes to mind as my soundbite is a philosopher during COVID said, if you behave, alisema nini? If you behave normally, where am I, Kikuyu? If you behave normally, the disease will treat you abnormally. Unakumbuka hiyo? So when I reflect on this, I just think abnormally, normally. It makes you think that way. War, is that normal? Invasion, is that normal? Diseases, is that normal? Disaster, hivyo ndivyo that nimejua inaitwa kipenge. Kipengele hicho kinatuambia. But for some people and for most of us, when it comes to our history as Kenyans, that normally, abnormally, you can't really tell. For example, nakumbuka watu wa Northern Frontier District. They still exist in a state of emergency. Military deployment, curfew, police presence, poverty, not being part of the state narration. They don't know, they're left out, wanatengwa. Is that normally or abnormally? I don't know. Other people, for example, who live in informal settlements. Every day, something has happened. Hakuna maji, hakuna services kama, I don't know, I'm trying to think here. Chakula, health services. Is that normally or abnormally? Hello? There are issues like drought. Uka? Thank you, now you're awake. Some go on for long, 3 months, 4 months, 1 year. Is that normally or abnormally? You're the ones who are thinking, not me. Nimesikia mambo ya femicide, and I saw some of our activists here. I saw them kwa task force, the one we had in Nakuru. And people are saying every day, a woman is killed. Every day. Is that normally or abnormally? I don't know. You'll tell me. COVID-19, all of us, we felt it, isn't it? Tulifungwa kwa nyumba, were told no more jobs, no more school, watoto wanafanya kazi online, sasa sijui unatafuta bundles, I don't know. Was that normal or abnormal? Article 58 is supposed to be for those situations, but the reason why people are scared, I think, even the courts, Mahakama yetu, the presidency, legislature, when they are called upon to trigger Article 58, they say ngoja kwanza. Ngoja kwanza. Because we are dealing with abnormal situations. That is the one thing I want to leave us with. But state of emergency in the past was used normally. That's also something I want to leave you with. The president had lots of powers to say, you know what? Today, state of exception. Tomorrow, no state of exception. So the 2010 Constitution, when you read it and how I've seen it being used in all these situations I've asked you of normally, abnormally, you'll see it's a last resort because of the many procedures there. And when you ask questions, I'll get into those procedures and even what the international law framework is giving us. Over to you, Emily.
Thank you so much, Victoria, Tracy, and finally, Melissa, for the updates that you have given. You have really stuck to time. It's now 17:23. We started at 17 hours, which is at 5 p.m. sharp. So I'll take 5 minutes or a few minutes just to go through the different provisions and that have been discussed by the panelists. I'll first start with, sorry if you see me looking down, I'm looking at my notebook. I will start with Article 59, which was discussed by Victoria, on the Kenya National Human Rights and Equality Commission. The name itself caused controversy, if we can start there. Essentially, was it supposed to be one commission or was it supposed to be two? And as has been discussed by Tracy, they ended up having two. That is the Kenya National Commission on Human Rights, and secondly, the National Gender and Equality Commission. But it reminds me back in terms of, if I look at the history of the commissions and the cases that have been determined on human rights commissions and whether they're working or not, is to look at the independence of these commissions. That's a good starting point to have. In one such case before the Supreme Court of the National Land Commission advisory opinion of 2014, the court had to look at the differences between the National Land Commission as an independent commission and the Ministry of Lands, where the functions were clashing. And in that particular instance, the court highlighted the different types of independence of what an independent commission should have. This independence includes functional independence, operational independence, and a very critical one that is plaguing a lot of our constitutional commissions, including the Kenya National Commission on Human Rights, which is the financial independence. And essentially, when we in that particular case, they tried arguing that commissions are firstly a fourth arm of government, meaning they move beyond the three recognized arms of government, which is the executive, the legislature, and the judiciary. But the court remained with the old Montesquieu, quote unquote, separation of powers in terms of the executive, legislature, and the judiciary, and so did not take the argument of there being a fourth arm of government in this commissions. But the functions of commissions essentially should be to check and balance other institutions in the work that they do. Some call them that they whisper truth to power, meaning they stand in between the people and the state, and they're able to whisper to the state truth in the actions that they're doing contrary to the citizen. That's how I like to simply put it. And for the Kenya National Commission on Human Rights, as far back as 3 weeks ago, there was already debates in terms of who should be the chair of the Kenya National Commission on Human Rights. And as this is being discussed, and we're looking also to the interrelated nature of some of these commissions, there are challenges arising in terms of the functions and the mandates that they carry out. So if you look at the Kenya National Commission on Human Rights is very broad. But then you have other institutions that are dealing with other rights, such as the Commission on Administrative Justice that deals with fair administrative action and access to information. But then how do they then balance, for example, with the NGEC that looks at the rights of minorities and women and other affected persons, and what the Kenya National Commission on Human Rights does? And then finally, if I conclude, is looking at the debates around the decisions that are made by these independent commissions. There was a case by the Supreme Court that essentially looked at the Commission on Administrative Justice and said that the recommendations that come from these commissions are not binding. But we have interesting commissions such as the Kenya National Commission on Human Rights, and the work that they do is very crucial. And are we looking at the powers that they have? Can the powers of the recommendations or actions that they do, if we look at the laws that they have, Victoria will probably go into this, bind people? Could it be converted into a court order so that it is effective? Could legislature change this so that their orders are effective? And this is a debate that is still running. There's currently an advisory opinion trying to seek the reinterpretation of that previous case. And it's something to look out for. It might bind one commission, but a question is, would it be applicable to others? And then looking at the issue of Article 31, Tracy really goes into privacy. And as we're talking the digital age, the right to privacy cuts across analog and the digital world. We found that the right to privacy, we would say, is an enabling right. For you to also enjoy other rights, you might have to enjoy your privacy. And I wouldn't, do I call it an enabling right? Let me put a star there. But when we talk of the right to privacy, we need to look at the privacy in the context of both analog and digital. Analog in the instance where privacy is such a highly held right that information is sometimes, or information and other rights are limited in order to protect people's privacy. We've probably discussed Article 24 and how powerful it is in the limitation of rights. And privacy is one of those rights that are used to limit the functions of individuals, private bodies, or the state when they're trying to enter into the realm, both the personal space of an individual, or even of an individual, if we think about it that way. There are cases where people have sought information on passports, on marriage issues of individuals, and they've said that is personal information, and the court has agreed that should not be disclosed. You can disclose information, but to this extent. So we find that information in the analog sense of being is also protected. Privacy. But in the digital world, we've spoken of issues such as Huduma number, and that goes into digital infrastructure. So when we look at digital infrastructure and how people are able, or the state is able to access a lot of information and data, how do you regulate that, as Tracy has discussed? And finally, one of the latest cases, maybe you might all remember, that we did as KATIBA is the I May number case. So the case that comes about the phones that you have, and the number that comes at the back of your phone known as an I May number. And Kenya KRA and the Communications Authority had sought to get the personal I May numbers. And we filed a case to show the court that that goes into privacy and breach of privacy, which the court agreed with, because it poses a risk of what is now known as mass surveillance, especially in the context of the demonstrations and what has been discussed. What are the challenges in having or information such as an I May number, that you have to be vigilant by KRA requesting your I May number? Why do they need it? And so this goes into surveillance at a level that should not be there. It's been appealed to the Court of Appeal. A notice of appeal, I know, has been filed, but it will be interesting to see what the Court of Appeal and the Supreme Court later state. And finally, when we look, and even privacy, look at privacy in the context of other rights, rights of personhood. When do people say they require their privacy? And look at it internally as an individual and see when is it limited and when can it be threatened. And finally, under the state of emergency, as Melissa has spoken about, recently we had during the demos where the military was brought in, and the Supreme Court in one of the cases discussed the context or the parameters of Article 58 and the state of emergency. And they discussed it in a case that dealt with the issuance of what do you call it, this thing that was issued during COVID, curfews, that was extensive in terms of curfews. And the court went ahead to look at Article 58 and say that, when that issuance is given by the president of a state of emergency, if I'm correct, then it brings in military law. And it removes the law that we know, which is the police law, the police service, and all that. And you can remember a few months or 1 year ago, there was an instance where the military was brought into Kenya. So think through something that we think is abnormal, as has been put by Melissa, but in 25th of June 2024, it was close to becoming normal. So some of these provisions are alive and well, and they breathe. But we often think that they will not happen. But I think the Constitution at 15 years reminds us consistently that those who sat and made the Constitution was for protection at such a time that they might not have thought would happen, or rights that we would not have thought would reach the context of the digital age and AI and digital infrastructure, that back 15 years ago, no one even thought of it as close as it is now. So thank you very much to all the discussants. I hope all the panelists, and I will now hand over to the team to ask the questions to the participants at the gallery. It would be good for you to hear from you.
Thank you. Thank you very much, Emily. I am seeing you're frozen. I'm hoping you have not left us. I just wanted to piggyback on her comments. I'm not supposed to have comments, but I wanted to give comments to both Victoria and to Tracy. To Tracy, when people write about privacy, they often ignore recent developments. So you'll find people talking about Huduma number case, which was a case, I think, in 2018, 16? 2019 there. So that's about 6 years ago. And yet, the most consequential body dealing with privacy right now is the Office of the Data Protection Commissioner and the Data Protection Act. And they issue determinations almost on a weekly basis. So it would be very important to look at that. Also, it would be very important to look at financial information and the number of attempts that the government has had to tax us more by getting our information from the bank. So for example, the latest attempt was an amendment to the Tax Procedures Act in the Finance Bill 2025 that sought to compel banks to give information about their clients. So you want to look at such provisions that become a lot more consequential about protecting our privacy. Also think about the controversy that came from people finding themselves on party lists for a party that you've never been a member of. How many of you are a member of ODM or UDA and you had never signed up for them? Do you remember? Yes, exactly. So that is an issue of privacy. And usually it comes from M-Pesa books, from signing up at the gate. For example, when if you come to Kabarak on a regular day, they will take your ID number, they will take your name, then that all of a sudden you become a member of KANU party. So, so this is some of the things that happen. It's something to look at in terms of the issue with privacy, and also to look at this issue of petitions to IBC that require, or applications to IBC that require 200,000 signatures. So for example, does that, when you want to do a constitutional review, you know, like, what was it called? Amani party that was trying to do a constitutional review. Punda Imechoka. Do you remember that one? Yes? Third Way Alliance, isn't it? Punda imechoka. Yes. And then they had to come up with, I don't know how many 100,000 signatures. And nobody, was anyone here somewhere where they were collecting signatures? Okay. At least I see one person. Any other person? I was not, but I suspect my signature was there. So, you see, those are some of the things that we're talking about. And how privacy is infiltrated. For Tracy, think about how the Kenya National Commission on Human Rights has two interesting histories that it needs to, that address it. Number one, the Kenyan Human Rights Commission was formed by by people in exile, political activists in exile in 1992. And the Kenyan government then responded in 2001 to the work of this KHRC by forming the Kenya National Commission on Human Rights. Okay? So it was formed by Willie Mutunga, who is now one of our faculty members, distinguished faculty members, Makau Mutua, and other political activists when they were in exile. Okay? And then secondly, look at the 2007 agreement between the one that brought 2008 National Accord. The National Accord then created the National Gender and Equality Commission and the National Cohesion and Integration Commission, NCIC. And it is that creation, that National Accord was constitutionalized. It was made a part of the 1969 to 2008 Constitution. And as a result, when the 2010 Constitution came up with the Kenya National Gender and Equality Commission, a problem came about, which was there was already another constitutional commission called the National Gender and Equality Commission, which had been given a constitutional status by the National Accord. So I suspect that the professors of law in our faculty can help you just contextualize what happened there so that you can understand why we have so many of them and why the duplication problems begin. Okay. Sijui kama kuna maswali mengine. Najua tumechoka, kuna chai, kumenyesha, tunasikia baridi, labda hata lunch imeisha tayari. Kwa hivyo sijui kama kuna maswali bado. Kuna mtu ambaye akona swali ambalo linamchoma hisia sasa. Hata haizi kaa nalo. Kuna yule ambaye akikalia hili swali litamletea madhara, ama tuwaweza malizia hapo. Sawa sawa. Kwa yale maoni ambayo tumesikia hapa, tumesikia kwamba kuna wale ambao wako na maswali ya kisheria ambayo yanahitaji usaidizi wa wakili. Kama mama ambaye alisema kuna shida ya mlemavu ambaye anadhulumiwa, anakatazwa kupata usaidizi ambao unahitajika katika sheria. Hapa kwa shule hii tuko na ofisi ambayo inaitwa CLACOL, inaitwa Center for Legal Aid and Clinical Legal Education. Yani bila kuingia kwa jina, tuko na ofisi ambayo inafanya huduma ya kisheria hapa. Kwa hivyo kama ungependa kusaidiwa, nimesikia kesi moja hapo, nimesikia kesi ya fluoride kwa maji Nakuru, na nafikiri ya Green mpaka akapatia one more ground ya kwamba maji ya Nakuru pia bei yake iko bei ya juu na inakiuka kipengele fulani cha sheria. Kwa hivyo naona ya kwamba kuna kesi ambazo zinaweza anzishwa, labda kupigania maslahi ya wale ambao wanadhulumiwa, Na kama kuna huyu kijana ambaye anaitwa Ian Ekisa, sio kama mnaweza muona, mkiweza kuwapatia contact zenyu, hata kama hatuwezi fanya interview leo, tuwaweza waita siku ingine tuone kama tunaweza anzisha kesi ama tunaweza andika mabarua ya kuwasaidia kufuatilia haki zenyu. Sawa sawa? Okay. Basi la kuenda Mogotio latoka saa ngapi? Ama limeshatoka? Watu wa transport, ilikuja leo? Okay, watu wa transport wangeniambia ili nifanye announcement. Basi hilo lingine nafikiria litoka saa 12. Sawa sawa. Mimi ningependa kuwashukuru nyote. Nje tuko na chai. Asanteni sana kwa kuja. Asanteni sana kwa kukaa siku zote 3. Wahusika hapa wamefurahi sana kwa maoni yenu na maswali yenu, na yatawasaidia sana kumaliza chapter za vitabu ambazo wanaziandika, na tutapomaliza tutaangalia venye tunaweza tuma kopi hata kama ni moja kwa kila kikundi ambacho kimehusika katika conference. Asanteni sana. Okay, najua nimecommit press kwa kitu ambacho hawako wanafaa kufanya, lakini najua ya kwamba hawataniangusha hapo, si ndio? Oh, thank you so much, Emily. I see you still online with us. Thank you so much for your facilitation. Thank you to all the authors. Thank you to the organizers. Okay. Kwa hivyo basi la Mogotio pia latoka saa 12. Kwa hivyo kuna wakati wa kunywa chai. Tafadhali tuende pale, tunywe chai, tufurahi, tujuane. Okay. Aha, nimeambiwa kwamba kuna kosa kubwa nimefanya, ya kwamba conference yaendelea pia kesho. Melissa? Okay. Sawa sawa. Conference inaendelea pia kesho. Basi la kutoka Nakuru Town litachukua watu bado saa 1:30 pale Shell, ile iko karibu na Masai Market, na basi la Mogotio vile vile mtaambiwa saa ngapi mtachukuliwa. Conference itakuwa hapa na pia Nairobi, kwa hivyo tutakuwa tukiwasiliana kwa mtandao. Wale ambao watakuwa hapa na wale ambao tutakuwa pale tutakuwa tukiwasiliana. Nimefurahi sana kwangu, na naomba kwamba tutaonana kesho. Enjoy chai, majaliwa. Asante.